Yes, Mr. Kohli.
I seek Lordship's indulgence to mention this batch matter. It's that APSC batch. It's item 33 to 76. Now, Lordship, in this one, essentially, these are challenges that have been mounted to disciplinary proceedings. And the show cause notice has been stayed in December 24, January 24. So we have filed vacation of those stays. And consequently, a reinstatement was directed on the basis of the stay of the show cause notice. So we filed a vacation of stay applications. In April last year, the learned court had felt perhaps we can hear both together. But for various reasons, and genuine and otherwise, the matter has not been able to be heard till now. So it was fixed for today and tomorrow, 2 consecutive days. So, Lordship, there were 2 requests subject to Lordship's indulgence, whether it can be heard today at some point in the second half, so the upgradation, so it doesn't get missed, and continuation tomorrow. We, of course, Lordship will at that time point out that we would like the vacation to be taken up because it's pending for over a year. And it's only against the show cause notice, so the DP is not proceeding.
We'll take it up. Don't worry.
We are grateful.
My lord, I beg to mention for listing tomorrow.
Motion.
May it please your lordship. Item 28, my lord, departmental proceedings against the petitioner have been dropped. My learned colleague, senior colleague is here.
Proceeding is go against the petitioner, my lord. But I have a submission that she has been given unnecessary harassment. Mental pressure she has been given by Elisa in this excess for this. So there's going to also be a caution not to do it in future. Also, you expect about I am ruled out in reason. And also cost may be imposed against the minister for their wrongful department.
Mr. Sharma, are you not asking too much? The instant writ petition has been filed. Mr. K. Sharma, the learned counsel, appearing on behalf of the petitioner. Ms. S. Sharma appears on behalf of the Guwahati High Court. The present writ petition has been filed challenging the disciplinary proceedings so initiated against the petitioner. Full stop. Ms. S. Sharma has placed before this court an instruction dated 18/12/2025, which is kept on record and marked with the letter X. From a perusal of the said instruction, it appears that the disciplinary proceedings so initiated against the petitioner has been dropped. Full stop. Under such circumstances, there is no live issue remaining. Full stop. Accordingly, the writ petition stands closed.
May I please, Lordship. Lordship, I am praying for listing. It is a content matter, Lordship. It will come in the order columns, Lordships. In next week, Lordship, 5th or 6th, any.
Data did. Tomorrow? Next week, then you file it, then it will come. Why do you, why you are mentioning it? Understood. If you want it tomorrow, then only you mention it. Otherwise, forget it. You have filed it, it will come. You don't mention it for that on Monday, it will come up. Must be for some good reason. Then you don't want it tomorrow. Then how can I help it? Don't mention it. Yes, madam.
May it please your lordship. I beg to mention item number 24 of the daily list.
24.
Yes.
Yes, what is this?
Lordship, we filed a IA in this matter. I'm just requesting for the calling of records. It's not been listed today. So we filed it just yesterday only. So the records may be called for your lordships.
No, the I will come up in the list. You have filed an interlocutory application. We'll adjourn this matter to some other day. In the meantime, the interlocutory application will come up.
Much obliged to you.
Your name,
D Gupta Lordship.
Ms. D. Goswami, who appears.
D Gupta Lordship. D Gupta Lordship.
D. Gupta, the learned counsel who appears on behalf of the respondent numbers 1, 2, and 3. submits the
Lordship,
interloc-
I appear on behalf of 1, 2 and 3, Lordship.
1,
two-
2, and 3.
2 and 3. One is APDCL, your Lordship. I don't appear on behalf of you.
You are appearing for whom?
High Print and Aprava, Lordship.
Who has filed the IA?
High Print, Lordship. Defendant number 3.
Who appears on behalf of the respondent number 3 submits that an interlocutory application has been filed. List this application along taking into account the above, the matter stands adjourned to be listed again on 17th of February 2026. In the meantime, the registry shall bring on record the said interlocutory.
Much obliged, Lordship.
I beg to welcome, publication of 7/25/2024
For
a listing
listing for what?
for, admission
Why?
of this, family pension letter.
Family pension. Dated at readable. First week of February.
May I please, Officer? Sir, I became item 9, my lord. Lord, I have instruction to not to paste this application, my lord.
Item 9.
Yes, my lord.
Your name?
Yes, ahead.
Mr. A. Jahid, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Lord.
Prayer for listing this matter for admission tomorrow. It's a
What?
prayer for listing this matter for admission.
Why?
The matter is regarding overstaying service. Lordship has already had a part of the case for us. If possible tomorrow, madam. or
No, not tomorrow. Not possible.
Next tomorrow.
It will be in the. Have I heard it? Little bit, then it goes to another little bit. That will be on 16th of February.
Item 77, personal affairs.
Madam, you are the Treasury Officer, Rongya? Are you the Treasury Officer, Rongya? I can't hear you. Something is mute. Madam, can you hear me? There seems to be some problem from your side.
Yes, Lord, maybe the mic is not.
Your mic is not operating.
Sir,
Yes, can you hear me now?
yes. Yes, sir, I can hear, sir.
Yes. Now tell me, this particular person, what is his name? Sankar Das.
Yes, sir.
He has been working in your office since when?
Sir, initial appointment, I have heard it, he was appointed in 2009.
Okay. And he has been getting his salary since when?
Regular salaries are from 2022. He is given.
Earlier?
But there is sometimes his budget is not given by, off and on he is getting. Sometimes it is off
No.
and
Has he got any salary from 2009 onwards?
no, sir. কিমান over পাইছে? Sir, regular salary is getting from 2022.
2020,
22, sir.
22. Prior to that?
Prior to that, no salary was given from this office. Maybe in 2009, one payment was given. But
Are
it is not
you therefore saying from 2009 till 2020, he
Yes,
did
sir.
not get any salary?
No, sir.
Can you put it on affidavit?
Yes, sir. I said that. Sir, it is not in continuous basis. His payment was not given in continuous basis from 2009.
Okay, so some part of payment was made in sometime
Yeah.
from 2009 onwards?
Yes, sir. In 2009, in 2011, 15,000 was made, and in 2009, 3,001 was made. In this way, some payment was made, but
Okay.
from,
Now, who was making the payment?
pardon, sir?
Who made the payment? Is it
Sir,
from the pocket expenses of the treasury officer, or is it from the budget allocated to the treasury office?
Sir, it is from the budget allocated from Treasury Office.
So therefore, the state was making the payment.
Yes, sir.
From 2009 onwards, intermittently certain payments were made.
Yes, sir.
But how, you see, the petitioner herein was appointed in the year 2009
Yes.
against the sanctioned vacant post.
Mm.
Have you seen the petitioner's appointment letter of the year 2009?
Sir, it was not actually in a sanctioned vacant post. The then Treasury Officer has appointed him.
The treasury officer, if he has appointed him on personal basis, then why the state is making payment?
Yes. Sir, actually, till 2021, the payment was not regular, but from December 2021, budget was allocated in his name, and from then onwards, he's getting his payments.
So therefore, there is an appointment order subsequently, or is it
No,
on the
sir.
basis of the 2009 order?
Only on the basis of 2009 order, sir.
So
Only
on the
budget.
basis of the 2009 order, the state government have started giving the budget in
Yes, sir.
2021,
Yes, sir.
isn't it?
Yes, sir.
There is no fresh appointment order.
No, sir.
Okay. So from then, from 2021, all these
Yes.
payments are being made.
Yes, sir.
So how are you showing it in your records as regards the petitioner's appointment?
Actually, our budget is allocated in a particular head of account, the wages head, and from the wages head, minimum wages 9,000 was he is getting.
Understood.
And-
So you see, normally when a budget is given to a particular office, it is against the persons who are actually working out there, isn't it?
Yes, sir.
Now, if there is an additional person who is working not in a sanctioned post, then you have to you have to submit a proposal for that.
Yes, sir.
Isn't it?
Sir, yes, sir.
When you submit that proposal, there is a budget allocation against that particular person,
Mm.
isn't it?
Yes, sir.
So therefore, on what basis did you propose? On the basis that he has been appointed in the year 2009.
Sir, actually, I have joined in 2025 February, but till then he is getting his regular payment. So,
No, there's no quarrel with
I
that.
was-
You see, why
I-
I'm saying is there's a reason why.
yes,
On
that's why I
11
have
to
continued that.
2025,
Hmm.
another court, another bench of this court had passed an order that this particular person was appointed as per the choice of the treasury officer without following any formalities. And
Sir,
as
that
such, the
order,
petitioner was asked, if you have any claim, make a claim before the treasury officer on his personal account.
sir,
But the
that order,
fact remains that the budget has been allocated from 2021 onwards insofar as the petitioner is concerned.
Hmm.
Meaning
that
thereby,
order-
you have submitted a proposal. You means your predecessor has submitted a proposal that this person has been working from 2009 and as such his services is required, and accordingly budget every year budget is being provided,
yes,
isn't it?
yes, sir. But yesterday we have got one petition, one order from where this point is mentioned. Actually, that this has come to our knowledge yesterday only, sir.
Which one?
Sir, that the
11
order,
to 2025 order.
yes, sir, it has come to our notice to yesterday only.
So
And
that
I have,
means the counsel who was appearing on behalf of your office did not intimate you because this was represented by you.
we are
You
not,
were represented, madam, your office was duly represented by a counsel
yes.
and you were not aware.
Sir, yesterday only I have, this has come to our knowledge and
Have you
immediately,
seen that order of 11-2 wherein there is a counsel who represents the treasury officer? Have you looked into it or not? How
sir,
can
it
you
is,
now say that you have come to know now?
sir, it has come to our
Notice was
knowledge.
issued in this case on 12/12/2025. In this case, a counsel duly accepts notice out here, and the counsel has not intimated you, and the part of that order is a part of the writ petition.
Sir, we have not got this information actually. And yesterday only I have informed this to our higher authority also. And I will in person visit our directors also regarding this matter. After getting it
Who
into
is
my
the
knowledge.
higher authority? Who is your higher authority?
Sir, Director of Accounts and Treasuries, from where the budget is allocated to the treasuries.
Respondent number 4, Lordship.
Mr. Solia, when a case is disposed or dismissed, you don't intimate.
Lordship, we do, Lordship, here.
Then here it has been categorically mentioned that you have not intimated.
Yes, Lordship, that,
That means
Lordship, that part,
that's a dereliction on the part of your duty.
yes, Lordship, that maybe,
You
Lordship,
you have put this noble profession to disrepute. Don't you think so?
Lordship, that might have been,
When you are appearing on behalf of the Treasury Office, so therefore it is an incumbent duty on your part to inform the officer that look here, this is the order passed.
Lordship, there has been a shortfall from our end, Lordship.
It is apparent from this order. That is why I was surprised when you are making the other submission yesterday. When the learned coordinate bench, yes, Mr. B. Gogoi, the finance person.
Lordship,
What is wrong out here? Yes, Mr. Noyak, you were the person who was the lawyer who was appeared on 11/2/2025. You did not intimate the Treasury Office.
Probably we did not.
Then that means certain payments have been made. A person, the court has held categorically out here that this person concerned, if he has to get any salary, he will get it from the personal expenses of the Treasury Officer. Now, from then onwards, from February onwards, this person have got their salary.
Yes, February 2025.
Isn't it on the basis that you, because of your not intimating the office, certain amounts of the state have been paid to a person who is otherwise not entitled to. Secondly, this very aspect that the person concerned have been appointed in the year 2009, and on the basis of his appointment budget proposals have been placed in the year 2021, and accordingly from 2021 the petitioner has been receiving this salary from the state, is a thing which ought to have been placed before the learned single judge. Then it was portrayed before the learned single judge that this was like a personal appointment. From the last 5 years, a person has got salary. Therefore, when the matter was taken up first yesterday, I put a question to Mr. Soliha. Where is the question of him asking, because he is not there?
So far as the earlier order is concerned, Lordship, it was a petition of 2018, and he was claiming dues prior to 2018. And that portion has been clearly denied by the learned single judge in that case. Yes, we should have been intimated it to the concerned authority. It is a fault on.
But the
our part
fact that
that
the
had-
argument when it was made on 11/2/2025, because this is an order passed on that day, this is
Yes.
not a CAV order.
Yes.
So on that day, this person concerned was receiving the salary from
Lordship,
2021
in fact,
onwards.
In fact, as it appears from the submissions made on our part, Lordship, in that case, Lordship, it appears, Lordship, that instruction, even we are not having that instruction, that he was getting salary.
Because you see, the petitioner has claimed current salary at rupees 9,000 per month.
Yes.
Paragraph 3.
Yes.
The learned counsel has submitted that there are recommendations made by the treasury officer for budget allocation as well as for payment of the dues which have not been paid or even hit to. But the fact remains that at that very relevant point of time, this person concerned was receiving 9,000. This is what the treasury officer says. From 2021 onwards, the person has been getting 9,000 rupees.
Yes, it appears now.
So therefore, without there being, and that too on the basis of an appointment of 2009.
Yes.
Isn't it the most strangest thing which can happen?
Yes, at that, on that day, Lordship, when this case was decided, that instruction was not with us. Accordingly, it was not communicated to the court also. But so far as paragraph 3 is concerned, Lordship, in that case, his claim was for an amount of 6,41,000. That was prior to 2018. So
No,
he-
with this observation last which has been given, the aspect of payment of 15,800 to the petitioner would not have any impact in the present claim for the Iman. Means 15,800 was paid prior to that. That is what the treasury officer says.
That-
We
that-
paid some 15,800.
Yes. He
Would not
received
have an impact in the
15,800.
present claim for areas as well as current salary. The claim, if any, has to be made by the petitioner from the concerned treasury officer, means the person who appointed. As it was on his pleasure, the engagement appears to have been made. But the fact remains, or is on that date, the petitioner was already receiving this 9,000 rupees from 2021.
But Lordship, fact remains that his initial appointment was not legal, Lordship. It was on the basis, it was merely an order passed by the treasury officer without any sanction from any other authority, Lordship.
No, Mr. Naik, I am aware of it. It is absolutely an illegal appointment. But the fact remains that if it is an illegal appointment after an order is passed by the court, the amount should have been stopped.
Yes.
This should have been forthwith stopped. Means, you see, this order comes on 11/2/2025. The budgetary proposal is submitted sometime in the month of February. For the purpose of it to be given effect in the month of March, the budgetary has to be put out there. A budget has to be given that there is a supplementary budget is required because there is a person who is not in a sanctioned post but he is working as some work. So this 9,000 is already paid on the basis thereof. So therefore, this additional budget has been created only on the basis of this. I am not on that the petitioner has a right to claim as per Jagdish Singh. No, he is no right. But the fact that it is, after all, the public money, on the basis of, and that too when the learned coordinate bench holds that, it is an illegal appointment.
Yes, Lordship. I admit it is a fault on our part also, Lordship, as it was not communicated. But at the same time, Lordship, petitioner also suppressed that fact. And he made subsequent representation claiming for minimum pay scale, Lordship.
You see, this statement which is there, paragraph number 3, the petitioner also claimed current salaries at the rate of rupees 9,000. Do you get it? Page 31.
Yes.
The learned counsel has submitted that there are recommendations made by the treasury for budget allocation. So this happened then, must be sometime around 2021, which the treasury officer now verifies.
Only thing I would also like to know from my officer, Lordship, whether this amount after December 2021 was paid as an arrear or monthly basis, Lordship.
Monthly basis. That is what she is saying. You see, they requested that on the basis of the 2009 order, budget should be allocated. And accordingly, from 2021, he has been regularly getting his salary. So therefore, I asked as to whether the salary he has been getting out of the personal pocket expenses of the treasury officer, or is it from the state allocation? So now the state, for the last so many years, has been paying, 5 years, has been paying to the petitioner.
Yes. At least it should not have been paid beyond February 2025, Lordship, when the order,
After this order,
yes, Lordship,
it couldn't have been paid.
February 2025.
Heard Mr. M.U. Mondal, the learned counsel, appearing on behalf of the petitioner. Mr. P. Naik appears on behalf of the Finance Department of the Government of Assam, as well as for the Treasury Officer, Rongia. Ms. Soenso, who is the Treasury Officer, Rongia, is also present through the video conferencing link. The petitioner herein has approached this court challenging and seeking a direction upon the respondent authorities to pay the petitioner the minimum scale of pay as is provided to similarly as is provided to the grade 4 staff in the Treasury Office, Rongia, Sub-Treasury, on the basis of the judgment of the Supreme Court in the case of State of Punjab versus Jagjit Singh, reported in 2017, 1 SSC 149. It is very pertinent to take note of that the materials on record show that in the year 2009, and more particularly, on 6/2/2009, the petitioner was appointed as a treasury officer, was appointed as a casual worker on monthly basis with immediate effect against the sanctioned vacant post by the treasury officer, Rongia Sub-Treasury. Copies of the said order were also marked to the Deputy Commissioner, Kamrup Metro, as well as the Director, Accounts and Treasury, which is Accounts and Treasury. It is very pertinent at this stage to take note of that the Director of Accounts and Treasury is the superior officer of the Treasury Officer The materials on record further show that the petitioner thereupon have been continuously serving, as would be seen from the certificates issued by the Treasury Officer. On account of non-payment of certain amounts, a writ petition was filed by the petitioner claiming an amount of rupees 6,41,700 as the arrears, along with interest at the rate of 9% per annum. The said writ petition was registered and numbered as WPC number 7696/2018. In the said writ petition, the stand which was taken by the Finance Department, by the Counsel for the Finance Department, was that the appointment of the petitioner was a personal appointment made by the Treasury Officer. Inasmuch as the Treasury Officer on its own inasmuch as the Treasury Officer was not empowered to make any grade 4 appointment. Be it as it may, it was also contended on behalf of the petitioner in the said proceedings that recommendations were also made by the Treasury Officer for budget allocation as well as for payment of the dues which have not been paid, and as well as for payment of the dues. This writ petition was disposed of by an order dated 11/2/2025, holding inter alia that the very appointment of the petitioner on 6/2/2009 was an illegal appointment inasmuch as the Treasury Officer did not have the authority to appoint, and with a further observation that the claims of the petitioner should be made before the concerned Treasury Officer, as it was on his pleasure the engagement appears to have been made. Paragraph number 6 and 7 of the said judgment order passed by the learned coordinate bench of this court dated 11/2/2025 being relevant is reproduced herein under. It appears that thereupon the petitioner submitted a representation on 24/11/2025 before the Treasury Officer seeking minimum pay scale in terms with the judgment of the Supreme Court in the case of Jagjit Singh Supra, until such time that his monthly salary, fixed salary of rupees 9,000 may be released. The said representation, however, having not been considered, the petitioner has approached this court seeking the relief as already aforestated. Pustam. Taking into account the observations made by the learned coordinate bench in the order dated 11/2/2025, wherein the very appointment of the petitioner has been stated to be a personal appointment made by the treasury officer, this court inquired with the learned standing counsel of the finance department that when the petitioner is very much not, when the petitioner is not there in the service, where is the question of making a claim for minimum scale of pay in terms with the judgment of the Supreme Court in the case of Jagjit Singh, Supra? The learned standing counsel Mr. Asolia, while appearing on behalf of the finance department, submitted that the petitioner is now being paid his fixed salary at the rate of 9,000 rupees per month. The question arose as to how, in spite of the very directions passed by this court, the petitioner had been paid the fixed salary of rupees 9,000 per month, and more so after 11/2/2025. It is under such circumstances this court fixed the matter today, thereby directing the Treasury Officer, Rongia, to be present through the video conferencing mode. Next. This court have also heard Ms. So-and-so, who is the Treasury Officer. It was submitted during the course of the hearing by the Treasury, by Ms. So-and-so, that since 2021, the petitioner had been receiving salary, a fixed salary of rupees 9,000, and it continues till date.
Just one line, Lord, page 34, Lord. This is a representation filed by the petitioner. Therein he is claiming that since June 2025, he is not receiving salary.
No, here it is there. Here, it is there. They paid. He's getting it. He did. No.
Subsequent.
No. Kili too. And continuously till date. This court inquired with the Treasury Officer as to who is making these payments. And in that regard, it was submitted that it was made on the basis of budget allocation being sought for or in other words, the payment has been made from the coffers of the state government. Or in other words, budget allocation has been made for payment to the petitioner, the fixed salary of rupees 9,000 since 2021. It was also mentioned that the order dated 11/2/2025, passed by the learned coordinate bench in WPC number 7696/2018, was never intimated to the treasury officer till যোৱাকালি ডেটটো। Taking into account the above, it is the opinion of this court that as the learned coordinate bench of this court, had already held that the very appointment of the petitioner to be illegal in the order dated 11/2/2025 in WPC number 7696/2018, and there is no appeal or review to the said order. It is the relief which is therefore sought for by the petitioner in the present proceedings cannot be accorded to the petitioner, since the order dated 11/2/2025 in WPC number 7696/2018 is set aside or modified full stop. Accordingly, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed. Full stop. It is further provided, before parting with the record, this court, however, observes that the dismissal of the instant writ petition, however, shall not preclude the petitioner to seek any review, if so advised, or file an appeal against the order dated 11/2/2025 in so and so. I've mentioned everything. Now, this will help you in seeking a review. But Mr. Naik is very unfortunate. If this is the status of how the government officials, the government advocates inform,
Obliged, Lord.
yes, mediation, is it possible? Possible. Possible.
Can be explained, my lord.
What is this case?
On the peak basis, initially compulsory death from the service. Then they were given retirement, compulsory retirement pension, everything they were given. But the challenge that compulsory retirement go down the court. Honorable court directed that that was held that the compulsory retirement was illegal and directed to give them notionally, reach that term notionally and give the retirement pension. Subsequently, that authorities had admitted that yes, they have reinstated notionally and they admitted to give the retirement pension also. But in the meantime, they did not give it, that they asked him to refund the compulsory retirement pension that they have given earlier, return. But he did not have the money, so they were refusing to pay the superannuation pension also. In that context, this petition was filed. During the pendency of the petition, that superannuation pension has been paid now. But now the ADR part, the Honorable Court has directed to calculate and give the fund. There is some discrepancy in the ADR part as per the petitioner.
So mediation possible. It has been submitted at the bar by both the counsels appearing on behalf of the parties that the dispute involved in the instant proceedings can be settled by way of mediation. Taking into account the above, list these matters again before this court on 15th of June 2026. In the meantime, the registry is directed to forward the writ petition, separate orders, to the Guwahati Mediation, Guwahati High Court Mediation
Mediation center, my lord.
Mediation Center, so that an attempt can be made to resolve the dispute through mediation. It is further observed and directed that in the circumstance, the mediation is not successful or is successful oblique unsuccessful, and a report is being submitted, comma, the registry shall forthwith list the matter before this court. Tinta. 1, 2, and 3, tinta regular. What is this? Mediation possible?
Compassionate family pension, claiming they are getting second wife, compassionate family pension.
Huh?
I am first wife, madam.
You are first wife. Why they are not giving it to you? You are divorced.
Second wife.
Nizu Khonwal. You are divorced. Then how can there be a second wife?
Maintenance was given at the time of service period, madam.
Huh? Huh?
Divorce was not.
Yes, yes.
In the local department,
PHC. PHC.
This is completed to private respondent number 8, madam, but she is not participating. Service also completed to respondent number, private respondent number 8, madam. She is not participating.
Yes, Mr. Talukar.
Yes, Lordship, he is getting the pension,
Who?
the private respondent, Lordship.
Why?
Because, Lordship, during his lifetime of the deceased employee, Lordship, all papers were submitted in her name, Lordship. She was the nominee, Lordship, and accordingly, pension papers were forwarded to us, Lordship, and accordingly we have settled, Lordship.
So as per the pension code, can a person say that, okay, my wife should not get it, should it
No, no,
be given
Lordship,
to somebody else?
At that point of time, her name was not in the, any.
Understood.
Yes, Lordship.
I am only asking you for my knowledge. A person concerned says that, look here, my pension, if I die, should be given to A, although B is my wife.
No, Lordship.
Can it be possible?
No, no, Lordship.
Or is it on the basis, pension is given on the basis of a statutory rule that it goes to the wife? You are
Lordship,
an expert on pension, tell me.
Lordship, as per 143, Lordship, first wife is entitled, Lordship.
Then
Lordship, but
the question is whether he is the wife.
Lordship. But Lordship, I filed my affidavit also, Lordship. I have
What do you
taken
say?
Paragraph 4, Lordship. Page 35, running page.
How can he be the wife?
Yes.
Respondent A be the wife.
Lordship,
Him-
all documents were in her favor, Lordship, and one next
no.
of kin certificate was.
Whether you have a marriage certificate.
26, madam, next to kin certificate.
And Lordship, form number,
Not
Page 26. Please find herewith the extract of the court's order in favor of Nizu Agarwal. You are hereby requested to direct your office preparing the pay bill to deduct an amount of rupees so and so and as area from the pay bill of so and so and deposit in the name and account of so and so as per the court's verdict. Modifying the earlier order, the disbursing officer of the second party is hereby directed to deduct so and so from. Where is it to show?
next to kin, madam, page 23.
Page?
23.
Next of kin nowadays is given to whoever you want. You want the next of kin of this Torun Khonwal, you will get it also in your name. What is your name?
Niju Sulman.
Your name.
Niju Sulman.
Your name. Huh? I am Kolta. You can also get your name. This is the status of this. These are sons and daughters.
Yes.
Oh. Then have you looked into this aspect?
Lordship.
Have you looked into this aspect? Who is the first wife?
Lordship, yes, Lordship.
And
Lordship,
not the
but,
first wife.
Lordship, but prior to filing of the writ petition, she was getting Lord.
It's a different thing, but you can still go and look into it if something fraud is there.
Yes,
If there is a
but
fraud, you are not going to look
Lordship,
into
that
it.
administrative department has to clarify, Lordship.
Have you submitted a representation to the PHE? Where?
Page 31.
Review the application for seeking compassionate appointment. Now I am requesting to receive for releasing compassionate family pension DCRG in favor of me on account of the service rendered by my deceased husband and scholarship. So, what to do? Want to go to mediation?
Private respondent from matter.
Private respondent.
She's getting Lordship.
This was completed, but till today he is not appear.
Is he represented? Private respondent?
He is getting pension, so yes, but he is getting pension.
That is why. We stop the pension by an interim order.
Lordship.
They'll jump in and come.
Then he
Lordship.
will-
Huh?
Then she will come.
Does you think so?
Yes, Lordship.
But have you prayed for that order? Stay the sanction order. Okay, sanction order. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukdar appears on behalf of the
Yes, ma'am.
accountant general. You are paying for somebody, director of pension. Mr. D. Vora appears on behalf of the director of pension. So none appears on behalf of the PHE department or for the respondent number 8. The petitioner herein who was married to late Torun Sonuwal and claiming to be the first wife had challenged the sanction order dated where's the sanction order? Have challenged the sanction order of payment of compassionate family pension to the respondent number 8 on the ground that the petitioner is the first wife and the second wife, and during the continuation of the marriage during the pendency of the marriage between the petitioner and late Torun Khunwal, any marriage with the respondent number 8 has to be a void marriage in terms with section 5(1)(a) of the Hindu Marriage Act 1955. It is seen that the petitioner has also obtained the next of kin certificate in that regard. On the other hand, the stand taken by the respondent by the account office of the accountant general in the affidavit, more particularly at paragraph number 4, is that late Torun Sonwal during his lifetime put the name of the respondent number 8 in the service book as the wife, and as such the payment was being, and as such the family compassionate family pension have been made in favor of the respondent number 8.
8 million.
This court have also taken note of rule 138. 138
143 compassionate.
143
143 lordship.
of the Assam Service Pension. What is the
Rules.
name of this?
Newly amended.
Assam Service Pension Rules 1969
Yes, lordship. Newly amended lordship.
as amended up to date,
Yeah, lordship.
and a perusal thereof reveals that the wife of the deceased male officer has primacy as regards the payment of the family pension. Pusto. Taking into account that the petitioner herein claims that the petitioner is the first wife, was married to late Torun Sonwal prior to the respondent number 8, and there is no divorce. It is the opinion of this court that the dispute in the instant case needs a resolution as to whether the petitioner is solely entitled to, or is it the respondent number 8. It is the further opinion of this court that in spite of notice, the respondent number 8 have not chosen to appear. Taking into account the materials on record and prima facie, also taking into account the next of kin certificate which have been issued in favor of the petitioner, it is the opinion of this court that further disbursement of the compassionate family pension to the respondent number 8 during the pendency of the instant writ petition would cause an irretrievable injury to the petitioner. Accordingly, this court therefore directs the
Treasury officer. lordship.
the treasury officer. Which office? Tinsukia. Not to further disburse the compassionate family pension to the respondent number 8 till the next date. List this matter again on 16th of March 2026. Actually appears for the treasury officer. You are there, PHE. You are not there when the matter is called. For you, you think that mediation, so why should I be there and give a consent that the matter should be amicably resolved? Isn't it? That must be your idea behind it. Yes, can it be mediated? My first question is you answer my first, then I'll go to the your question. Are you ready for mediation? No, no, I'm asking you, is it reasonably possible that there can be a mediation? My question is that, is it possible?
My lord, the read petitioner, she is claiming that she is the first wife. Till date, I have not received any instruction from the district judge office, my lord.
Huh?
To confirm whether she is the first wife or not.
Who is the first wife?
Claiming to be the first wife. I'm claiming to be the first wife.
And who is the second wife?
The second she died a year after my husband died. Meaning thereby my husband died in 2019.
You are Hindu? Where is the second wife then? Concept?
Second wife, there is no concept.
Then?
The ages of the children themselves show.
Huh?
The ages of the children themselves show it. My daughters are aged 47, 43-year-old. Second wife who has 2 sons, they are aged around 30s, 20.
So?
And so that is the later in point of time. Both were, there is no certificate, marriage certificate, it was all solemnized.
Second wife is dead.
Second one died 1 year after their death. She claimed pension only for few months.
She got it.
She got for a few months. So
But where is your marriage certificate?
I do not have a marriage certificate. Mine was solemnized long back in by way of Hindu rights.
She was 73 years old.
Yes.
I am 73.
And so you are not giving anybody pension.
No, as of that, after
Then why?
my lord, we cannot ascertain, my lord, because of
Why are you not clearly stating that you don't trust the next of kin certificate? Tell us. Which
Well,
department you are? Huh?
district and session judge Lakhimpur, my lord.
Then? She has produced the next of kin certificate. Nilima Gogoi, have you produced it or not?
Yes, yes. Page 15.
Then? We Nilima Gogoi so and so that our father was the registered owner of a vehicle bearing number so and so. Have you taken something from the court? Huh?
I haven't taken anything. Question of an interim order, they are not paying anybody.
Wait. Two sons, 29 and 21. Roktim Borgohai and Devashish Borgohai. They are the second wife's wife.
They are the second wife's son.
Second wife's son, my lord.
And daughters, both married.
The daughters are married.
So son also they don't get it. So it is you. So you have to get it. Yes, what is your instructions?
My lord, waiting for instruction, my lord. I need some time, my lord.
The 2024,
My-
High Court matter.
My lord, what happened, my lord? Nobody appears, my lord, in this matter. On last occasion,
Yes,
your
sir.
lordship,
Initially, my lord, the government advocate stated that he would be appearing, but thereafter no instruction came and thereafter the senior friend was appeared.
I am appearing for the first time today, my lord, in this matter.
No, first time or
My
second time.
lord.
When are you going to give are you waiting, both of you?
Mo-
You and you, both of you are waiting that this person also should die. She's 73 years already. And now it's 75. He's already have the platinum jubilee. And now you are doing all these things. And it can't happen like that. Get your instructions next week. What are you taking up? Have you considered their representation? You have submitted a representation, Mr. Bolwa.
That page 27.
Forwarding the application submitted by, to accountant. Who is the accountant general? Where is the accountant general?
My lord, none
Where
has
is Mr.
appeared.
R.K. Talukdar? He was very much here. We'll take it up. We get hold of Mr. R.K. Talukdar. We want to have him. What have they done it? They can't sit on this like this.
Passing the buck, they said that if they agree, then they're ready to pay the pension.
Who agrees?
If the district.
You agree? You are not going to pay from your pocket. You agree? Yes, Mr. Sibova. You are also Accountant General.
Item 5.
This is regarding a pension of an old lady who is 73 years old. Her husband, she was the first wife. And during the currency of the first wife, the second wife came in. He married the second wife. Second wife got the pension for 1 year, and second wife also died. Now the first wife comes over and says that actually I am entitled to. So when he is entitled to or not,
Biplab Chakraborty, sir, in
who?
number 18, Biplab Chakraborty for AG Lodge.
Who is appearing?
Biplab Chakraborty.
He is not there.
He is under court.
You don't have the instructions. Chalo. We'll have it at 4:45. Tell him, because of him this will happen. We'll have it at 4:45.
Aulaj bhai.
Item 6.
Yes, Mr. Sibulwai, this is your matter. What is this? Possible for mediation?
Maybe.
Is it possible, Mr. Sibulwa?
For a moment.
You have accepted notice?
Yes, I have received it.
Oh,
Can be, I think.
release his retirement benefits and other benefits.
This
What
Panchayat
benefits?
is governed, Panchayat Rural Development, AG doesn't pay pension because that is by director of pension. For education and Panchayat, we
He
don't.
must have been most probably regularized. Pay commission along with medical allowance.
Panchayat department, na? Right, na? Panchayat and Rural Development, we do not do. Yeah, he, I mean, no, full.
Lordship, they are not enclosed any regulation order also. Lordship.
Madam, it seems these people have been given, where these people regularized?
But not enclose any
These
regulation order.
people have been given the last round wages, minimum of the scale of pay.
Lordship.
It seems so. And but you see, these posts are personal to the respective casual workers as stated above and will be abolished soon. Meaning thereby posts were created, supernumerary posts were created, which means they were regularized.
But not any enclosed regulation order. Yeah.
This is the order. No instructions, no, madam.
Lordship, actually, I misplaced the file. So kindly more time may be given. We'll reconstruct the file and we'll then take instructions.
No, it is
for
not
that
your
purpose.
mistake, madam. It is some P. Hendick who has taken steps.
Earlier,
And yes, therefore it is
Lordship.
not your mistake.
Lordship,
You give an additional copy to her. And we put your name
Lordship,
shall be reflected.
Lordship.
The petitioner herein has approached this court being aggrieved by the non-finalization of his retirement benefits.
Lordship.
Non-finalization and release and non-release of his retirement benefits. Pustup. On an earlier occasion, one Mr. P. Hendy, the learned standing counsel of the PNRD department, had accepted notice. But it is being submitted by Ms. N. Bora appearing on behalf of the PNRD department. That a copy of the state writ petition, however, is not available. Considering the above, Ms. So-and-so appearing on behalf of the petitioner shall serve an extra copy to Ms. N. Bora, the standing counsel of the PNRD department. Pustup. The said standing counsel of the PNRD department shall obtain instructions as to why the petitioner have not been paid his retirement benefits. Pustup. By filing an affidavit to a competent officer of the PNRD department. List this matter again on 18th of February 2026. Only that. I think he is not entitled to any pension. He may be for some terminal benefits he may get. As per that, nothing more than that. Yes, Alom. Yes, you want to go to mediation? You want to take him to mediation?
Yes, no problem. Dispute is between the private, the two wives.
Two wives.
Yes. And the both cannot exist at the same time, Lordship.
First wife, Lordship. Question number 8 is the second wife, Lordship. I have no objection in sharing the pension, but the department has not released the amount, Lordship. And
I have
so all
already
things
filed
Lordship,
an affidavit, Lordship. I have
all
already
things
filed.
Lordship.
You are a first wife?
Yes, Lordship.
You are a second wife?
Second wife, Lordship, suffering from cancer, Lordship. So,
Who?
second wife, Lordship. So, Lordship, immediate.
So you what do you want to imply by saying the second wife is suffering from cancer? That is an additional reason to give it to you. Why you are implying that? It is treatable nowadays. Anyways, payment order is being given. Joinal Abidin.
May kindly come to my affidavit, Lordship.
Yes.
Page 23, error number 5, Lordship.
Your affidavit, I don't find it here.
Apply, even if I don't. Now apply.
I filed it on 29/8/25.
Give it to me, a copy. You have it? You have a copy? What do they say? You have it here with yours. Seven a.m. where so and so deponent stated Lena was an employee of the joint hierarchy in the post of Corsa and retired on so and so. Ramana was submitted all the records clearly stated that Sujan become his wife and Jasmine Abidin and they are other daughters gave no information in this office regarding his other wife. And I have received pension so and so. Okay. No, in view of the full bench judgment, it is the first wife who will get it and then they will share it. Then we do one thing. We send it to mediation. Both of you come up how much, whether you are agreeable for that. And on the basis of that, then I pass an order directing them to give it and it release in the ratio of so and so. Only that.
I'm sharing, I am ready to share with you. And the first.
You?
He has also filed the same.
Settle it.
Settle. 50-50.
Yes.
So you give it to the name of so and so. He is going to give it to you. Because you have to give it to only one. You can't give it to both. So you give it to her and he gives an undertaking that both of you file a joint affidavit 50-50.
Yes.
We'll take it up tomorrow, day after. Tomorrow you can file? No, not possible. Man. You see, both of you agree 50-50? Then I am more particularly about you because tomorrow you may say that I am not really going to give it to him. Where?
And he has also filed a deputy leadership for
Huh?
number 8 has also filed.
Where? Where is 50%? Prayer?
Yes, 12%. They are number 2.
Prayer number 2, what do you say? Release the EI in equal share to the petitioner and EI. Can you, madam, you don't share equally. You give it to one point and they have to give it to others. That is what, no. So it can be given to only one person and then it has to be shared. You have to share it. That is the reason why I want your affidavit. Put an affidavit that you, if a year is being given, I'll give 50% to him during his lifetime or to his legal heirs. And the legal heirs won't get it. They are already aged. The others won't get it. Till her lifetime, you'll give 50%. File an affidavit. Okay? Because the others, those don't have a right. Unmarried daughter, if there is there, it may be something like that. Any unmarried daughter? No, all are married. So therefore, you file that affidavit. We have it on Monday. Can you have it? Only short affidavit today. By tomorrow, full stop. They heard Mr. S. Olom, the learned counsel appearing on behalf of the petitioner, and Mr. What is your name? M. Islam. M.H. Talukdar, who appears on behalf of the respondent number 8. It's an admitted case that both, and it is an admitted case from the records, and more particularly, the next of kin certificate issued by the, who has issued this? By the Circle Officer Bilasipara, Annexure 3 to the writ petition. That the petitioner is the first wife and the respondent number 8 is the second wife of late Joinal Abidin. The claim of the petitioner herein is that is any pension paid to him? No, no. It is the claim. It is the claim of the petitioner that the pension, the family pension, which the petitioner is entitled to by virtue of section 143, rule 143 of the Assam Pension Rules of Pension Act 1969. It is 143. 143. That the petitioner is entitled to the same. Full stop. The counsel appearing on the behalf of the respondent number 8 also submits that he has no objection in the petitioner receiving the family pension subject to the petitioner parting with 50% of the said amount to in favor of the respondent number 8. The counsel appearing on the behalf of the petitioner also submits that the petitioner is agreeable to do so. It is the opinion of this court that such an aspect be brought on record by way of an affidavit by the petitioner that during the lifetime of the respondent number 8, the petitioner would part with 50% of the family pension. In the circumstance, the petitioner is paid the family pension. List this matter again on 10/2/2026 at 2 p.m. for final disposal. Affidavit be filed on or before 9/2/2025 by the petitioner. Mediation possible?
My lord, the pensionary claim. It's a claim for pension, my lord. By what appears to be apparently the second wife, my lord.
Second wife.
Her name was never in the service record, and the difficulty is that we had taken an objection, my lord, as to jurisdiction. BSNL, my lord, the jurisdiction lies in the CAT. It lies in the administrative tribunal, my lord.
Cat.
First, I had approached the respondent authorities, but my application has not been accepted. But first let them entertain my application, and if some issues are there, then I'll approach the concerned authorities. I try to.
It is not an authority, it is the court of the first instance. Go to Cap. You want a short order, long order, which one? Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Pathak appears on behalf of the respondent number
1 to 4.
1 to 4. So-and-so appears on behalf of the respondent numbers 5 to 8. Who are you?
They are the sons, my lord. They are all major, therefore they don't have any claim on the pension as such.
You have no mother. The mother.
Your Honor, 5, 6, 7, and 8. 5 and 6 are sons of the petitioner, and 7 and 8 are for the other wife of the deceased husband of the petitioner.
Other wife is alive.
No, she is also, my lord, no more. She is also no more. Immediately after death of the husband, she died even before receiving pension.
Who died?
The first wife, my lord.
Predeceased the husband.
No, she died immediately after the death of the husband.
Who is the nominee?
Okay. And you cannot be the second wife. How can you be a second wife?
Your Honor,
When did you get married?
1993 I was married.
Married.
And the first wife?
First wife, we don't really have the date, but the sons, my lord, the eldest son is 41 years old as per the NOK, the next of kin certificate. So therefore, definitely was born before 93.
Your Honor, the dispute regarding the wife is not there because all the sons have given declaration that
Your marriage is illegal. Your marriage is illegal. Where do you get it? No, it's a void marriage.
My lord.
With a void marriage, how can you get pension?
And had the children been minor also, we
Well,
would have considered.
Children would have got it, but not you. What should I do? Dismiss it totally? Or where? Where should I do?
Not even
send
dismissal
it
might be
to
difficult because jurisdiction, if the issue of jurisdiction is there, my lord, the dismissal order also has to come from the CAT.
Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent number 1 to 4. Mr. So-and-so appears for respondent number 5 to 8. The petitioner who claims to be the wife of late Amrit Chandra Nath has approached this court being aggrieved by the inaction on the part of the respondent authorities in making payment in paying the family pension to the petitioner. There's no denial of the fact that the petitioner got married in the year 1993 after late Amrit Chandra Nath had already married one, what's his name?
Khewali Devi.
Khewali Devi. The materials on record also apparently show that late Khewali Devi died subsequent to the death of late Amrit Chandra Nath. The question arises under such circumstances as to whether the petitioner can at all be entitled to any family pension. More particularly, taking into account Section 5(1)(a) of the Hindu Marriage Act 1955. Which stipulates that the second marriage during the currency of the first marriage is a void marriage. Be that as it may, Mr. B. Pathak, appearing on behalf of the petitioner, submits,
Respondents.
on behalf of the respondent numbers 1 to 4, submits, they taking into account the judgment of the Supreme Court, of the Constitution Bench of the Supreme Court in the case of L. Chandra Kumar versus so-and-so, reported in so-and-so, and more particularly paragraph number 93. And Section 14 of the Administrative Tribunals Act 1985, read with Section Rule 154 of the Central Administrative Tribunal Practice and Procedure Rules 1993 and Appendix Roman 6, this court may not like to entertain the instant writ petition. Taking into account the said submission, this court finds it pertinent to reproduce paragraph number 93 of the judgment of the Supreme Court in the case of L. Chandra Kumar. A perusal of the above quoted paragraph of the Constitution Bench of the judgment in the case of L. Chandra Kumar Supra categorically observes that the High Court should not entertain a dispute which falls solely within the ambit of the Central Administrative Tribunal. Now, the High Court should not act as the court of first instance in respect to a dispute which falls solely within the jurisdiction of the Central Administrative Tribunal. Considering the above, this court therefore is not inclined to entertain the instant writ petition, and writ petition accordingly stands closed. Liberty, however, is given to the petitioner to is accordingly dismissed. Liberty, however, is given to the petitioner to approach the Central Administrative Tribunal if so advised.
Okay.
Mediation?
My lord, I have filed my affidavit, but it has not come into the record.
Understood. Is it possible to send it for mediation?
Well,
Mr. Hawk, what are you doing in these type of matters?
okay.
You are the most famous lawyer doing matters for
Or my lord, he can approach the armed force.
site verification, and now what are you doing with this pension matter? Area pension to the petitioner in respect to the death of so-and-so against his till, and family pension to the petitioner till date is admissible. Yes, why you are not giving it?
My lord, we have already, initially he was employed as SEPO, my lord. Then thereafter he was again re-enrolled. So the second part he's getting the pension. First part it was stopped because due to the Rule 269.
Okay. Heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner, as well as Mr. G. Pegu, who appears on behalf of the respondents. Mr. G. Pegu, the learned counsel, submits that the petitioner herein is not entitled for the first part. Prior
No, not.
They are not delaying. They are not delaying. In fact,
But it's
they
time
are
barred.
affidavit.
Time barred. And we are not getting response from the treasury officer. And treasury officer is not a party in this case. That is the difficulty.
And Mr. G. Pegu submits that the respondents are contesting the instant application by filing the affidavit. Taking into account the above, the instant application cannot be sent for mediation. Accordingly, list this matter again on 18th of February 2026. In the meantime, the registry shall bring on record the affidavit which have been filed by the respondents, whose liberty given to the petitioner to file reply thereagainst on or before 16th of February 2026. If you want, bring that treasury officer.
Yes, ma'am. They were for BSM.
Possible mediation.
Lordship, we have already issued instruction to the treasury of the petition.
Nothing immediate. It has been submitted by the council appearing on behalf of the petitioner that the petitioner have already received the benefits have already received the benefits for which the instant writ petition has been filed. And in that regard, have placed before this court the communication dated twelfth of February 2019. 25. This is 2025.
Yes, Lordship, because we issued the instruction on 13/2/25.
Oh. Very good. On 12th of February 2025. Full stop. The said document is kept on record and marked with the letter X. Taking into account the above, the instant writ petition therefore stands closed as infructuous.
Lordship, I'm appearing for respondent 1, 3, and 4.
Give your names.
Lordship, I'm for the AG, Lordship.
Yes, what is this case?
The daughter of petitioner, the daughter of the pensioner who died in harness structure.
Is the daughter of?
One fully with who died in harness structure.
Putuli Polita.
Dependent divorce daughter, your lordship.
Huh?
Dependent divorce daughter.
A dependent divorced daughter also gets it.
Yes, your lordship, I've just placed your.
I have to pass an order.
Yes, on 21st. This is the date.
Now, where is the divorce?
Decree. It's 14.
Huh?
It's 14.
Where is the divorce decree? Ah, here. Here, this FC Civil 1063. Second site let me remove. And dispose of.
21st.
Second site label ID.
Oh, let's. For attention, I get 30. Okay, whatever protection.
Sweeper. It has not come. So let us wait for some time and then tag along with this matter. List this matter again on 19th of February 2026.
Fine.
taking into account that the petitioner have already, the counsel for the petitioner has already submitted that a fresh petition has been filed.
17 March.
Yeah.
What it is,
So basically, this matter is regard to the petitioner being having a rank of 1961 in a list, lordship, a person under disability having 50% disability. But the contention here is that it's agreed by the inaction of the.
yeah, why you have filed your.
We have not
preliminary-
filed, lordship. In fact,
preliminary-
I've been in contact with my Carlis lordship, informed me that on the last day itself, the copy of the petition has been served to you. So basically, they are praying for some time from the court, lordship.
How much? Only one simple question. Why the petitioner has not been selected?
That is the yes.
Why? They inform you many things. That we have got the copy recently, all these things are there. But the fact remains that why? Submits that instruction as called for has been received by his colleague, Miss M. Bhattacharjee, the learned, and the same will be placed on the next date of hearing. This is what happened before on 21/2026.
yes, sir, sir,
Miss M. Bhattacharjee
Yes,
has
I have contacted her. She informed that on that day itself, the copy of the petition was supplied to the party. So accordingly, lordship requested me to pray for some. ¿Qué pasa? No. Otherwise, the issue is only that issue, lordship, whether
Now, Mr. A.Y. Chaudhary, one instruction was sought for by an order dated 5/1/2026 as to whether any person below you have been appointed.
Yeah, all information is provided, thereafter, consultation with the authority, in that we have one information from the respondent authority.
Mr. C.K. Asbulwai, what you are saying is completely again opposite to what is recorded in the orders. So, who is the person who can give us this information?
lordship, if you're not the chairman, state level police recruitment board, lordship.
Chalo, let us see his face on Wednesday, 10:30 AM.
Before they let me.
No. Let us see his face on 10:30 AM. Because what is this? Every council of the government is putting the buck on the other person. You say that M. Bhattacharjee, you say somebody received the petition recently and sent it. On 21/2026, the order says that they have already received the instructions. Now, what should I believe? Tell me.
Okay. I understand, lordship. Difficult for me also, lordship.
Read the order. Oh, great. Tell me.
Very difficult.
So what you are saying is quite the opposite, isn't it?
WhatsApp message and what the WhatsApp message.
So therefore, let us see the face of that central and say these councils have not keep up to the expectations of these officials. Problem arises because of that. Yesterday, I was constrained to pass very strict orders
Lordship.
upon the council. But I'll still continue to do so. A repetition of the year 2024, you have no instructions. Like I heard Mr. A.Y. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. C.K.S. Borua, who appears on behalf of the respondents,
1, 3, and 5.
and you appear for? On behalf of the respondent number 4. The grievance of the petitioner is that the petitioner is a disabled person, is a person with disability, and he had applied pursuant to an advertisement dated 30/12/2018 for the post of grade 4. The petitioner appeared in the interview on receipt of the call letter. The results were declared and a merit list was published wherein the petitioner was at rank 1961. The grievance of the petitioner is that in spite of the petitioner being eligible and have fared well, the name of the petitioner is not featured in the select list. Now you are there in the select list.
It's only been not communicated.
The grievance of the petitioner is that although the petitioner's name appears in the select list, where is that? Page? 30? 32, 1961. Here. Is in the merit list. In the merit list. Having secured total 12.5 marks. But there is no intimation given by the respondents herein as to whether the petitioner would be recommended for appointment. It is under such circumstances the petitioner had approached this court by filing the writ petition in the year 2024. Notice was issued as far back as on 16/12/2024 and 19/8/2024. It, however, shocks and surprises this court that the respondent authorities have not placed the instructions. A perusal of the orders passed by this court reveals that each counsel who appears on behalf of the respondents, each new counsel, fresh counsel who appears on behalf of the respondents, puts the buck on the earlier counsel. And thereby, the instructions is not complete till date. It therefore appears that the counsels who have appeared on behalf of the respondents till date have not done justice to the duty reposed upon them by appointing them as counsels for the government. This court fixes this matter again on 6th of February 2026. Either the respondents shall provide the instructions to the petitioners, to their counsels, as regards why the petitioner have not been recommended for appointment, or the chairman of the state levels police recruitment board shall be personally present at 10:30 a.m. to answer to the queries, to the instructions sought for. Or given.
This matters, the rule is at the final stage, Lordship is aware that fifth, maybe taken up, yes.
List this matter on 5th of March 2026,
Fine, my lord, fine. Highly obliged.
taking into account that the rule, draft rules is at the final stage.
My lord, my lord. Highly.
Mr. Pathak, there has been a lot of changes to those rules. Now I think the rules are in a proper order.
Substantially improved, my lord.
There are a lot of, again, there are further modification which is going on, and I
Regarding
think.
that, regarding that accountant and all
No,
those
the
things.
accountant is there, but many other modifications are there, and now it is being drafted out in a much more legislative manner.
Correct, correct.
Proper interest.
Yes. It is. In fact, I think that the intervention of the legislative department of the government of Assam
it's
was
helpful.
for good reason.
It was helpful, my lord.
It was necessary because otherwise later on we came to learn that yes, there were a lot of folly.
Highly.
Mr. BP Bora, yes, tell me what is your case?
Is of promotion, the post of senior editor from junior editor.
Motion made in favor of the right, not in consideration of the the second as to how the selector has to be evaluated. Affidavit filed, everything done?
Done,
Where is here?
on 14th, after perusal of the record, the constituent passed an interim order stating the entire effects.
Yes, I passed an interim order, I've seen it. Considering the above, the order dated so-and-so by which the respondent has been promoted to the post of senior administrative assistant is state till the next date. Then? Till the disposal of the year. G. Bushra has filed. Where is he?
I have filed my reply also on 5th.
So High Court counsel is not there. None is appearing. What is wrong?
Sorry, my lord.
It is unfortunate when the matter is called for. There are counsel for the Guwahati High Court as well as for the private respondent is not present, for which the matter could not be taken up for final disposal.
In this-
Accordingly, list this matter again on 12th of March 2026, on which date an attempt shall be made to dispose of the writ petition. Full stop. It is further observed that in the circumstance, the High Court counsel as well as the counsel for the private respondent is not represented, the instant writ petition shall be taken up for disposal in their absence.
Lord, I'll inform Mr. Bosho, my lord, perhaps he is appearing in this matter, my lord. I'll inform, my lord.
Inform that because of this, I can't took it.
Fine, my lord, I'll inform. Much okay.
Lordship, kindly come for the matter for timing, Lordship.
Why?
Lordship, my senior is on legs in court number 5, Lordship.
What is the matter about?
Lordship, the matter relates to the transfer of a LIC employee,
Huh?
26 items.
Who wants what argument?
Lordship, we have filed IA for state of his transfer order.
For?
Lordship, actually, Lordship, kindly allow me to give my brief, Lordship.
Allow you to?
Fine, Lordship.
You didn't know the matter would reach.
a very short matter.
Yes.
Done, madam. It's in the file. I'll take just 5 minutes.
So by the 5 minutes you take, if I'm convinced with your case, she will be allowed another 4-5 minutes. Then we dictate. And in the meantime, Mr. Kane should reappear. We put his name out there. You are enjoying an interim order. Until further orders, the impugn order dated so-and-so in miscase number arising out of so-and-so. What is section 2A around the?
See, confined circumstances, dismissal, discharge and retrenchment. Now it's confined to that only. If any other matters, the entire, the case which is filed.
This is the Code of Wages Act. It's a very new matter. Code of Wages Act came on 3/11, na?
Yes, but it tenders to dispute matter. Now, section 2A defines if a individual workman is a dismissed or discharged or retrenched, he can come individually, not for union. Before, my lord, without reference, my lord, he can come before the court. Now, here.
2A is in the Industrial Disputes Act.
Yes,
But we are concerned with section 2A of,
we have industrial dispute.
why is it being written about 2025? You are challenging the jurisdiction. What order has been passed?
My lord, what the.
Miss case number so-and-so heard learned counsel, the present case is preferred by the applicant management for rejecting a complaint petition filed by complainant. So-and-so, read with so-and-so is not maintainable either, and it has been claimed that ID Act apply only to workmen category as per so-and-so, and has been referred to as an employee discharging managerial or the entire complaint is based on internal
Transfer order.
service dissatisfaction for the Why such a long order? Perusal of the documents and next report, it is evident that the complaint though has the supervisor head the office, but his primary function is to perform skill and technical function with regard to handling of junior staff, wherein he does not possess any self-authority to appoint or dismiss a person. So you are not on the question that he is a workman.
Well, that question I'm not happy.
So you are only on the question that whether an application under 2A is maintainable. Industrial dispute section.
The only question, my lord, dear lord.
Where an employer discharges, dismisses, retrenches, or otherwise terminates the service of an individual, any dispute or difference between that workman and he are connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of the parties made, notwithstanding any person is can make an application directly to the of the dispute referred to therein after expiry of 45 days from the date he has made an application to the constitution and therefore constitution of the. So you say that unless it is a case of discharge, dismissal, retrenchment, or otherwise termination of service, the question of 2A is not there.
Please, no other matters can be entertained. And
That's
the
all.
last tribunal is entertaining the transfer matter. So therefore, this without jurisdiction. But even the appeals court has said it plus this one. The lordship has said, no other matters can be entered, it says and except dismissal, discharge and dismissal. So that's the end of them.
No, Lordship, actually, I have approached before the Honorable Tribunal Court under section 33, 30A of the Industrial Dispute Act.
Show me your
highlighting-
application, where is it?
Application is not annexed in writ petition, Lordship. Lordship, main with the case which is pending before the labor court, Lordship, regarding the mental.
Where is the
harassment-
application?
The lordship will find it phase 44.
writ petition.
Complaint under 2A, read with 33B of the industrial highlighting issues of workplace harassment. Malafide, punitive transfers, amount to constructive dismissal, targeted victimization, systematic corruption, abuse of the young, unfair labor by young. Section 30.
33, they want to say, they are protected one. Can you also can you see section 33, subsection 3. Not maintainable, then all this thing will not come.
During the pendency of any conciliation proceedings before a conciliation officer or a board or any proceeding before an arbitrator or labor court or so and so in respect to no employee shall in regard to any matter connected with the dispute alter or prejudice concern here. So there is no matter pending.
No matter pending.
So therefore 33 won't come in.
Not affect at all.
And 33(3)(b) is what?
33, 3 may not.
Notwithstanding anything,
Notwithstanding anything.
then into no employee shall during the pendency of any in respect to an industry take any action against the protected. This is for protected workmen.
He is not protected, there is no abandonment.
Oh,
he is
sorry.
a protected
No
workman.
matter. Finished.
No, Lordship, what happened here, Lordship, actually, initially, I have approached before this court by WPC number 2366/2025, where I have challenged my punitive punishment transfer 24/4/2025. But at that point, there is a question whether the LIC Finance Limited falls under the Article 12 of the Constitution or not. Thereafter, then there is a question arises where the LIC house, Lordship, may I read my order? There,
Is that,
no, it is not annexed in petition, Lordship.
now you are referring to which order? Earlier order?
Yeah, it is not in petition, Lordship.
Huh?
It is not in petition. Earlier litigation, there are two other earlier litigation. One is 2366, which I have withdrawn, Lordship.
Yes, what?
Council, Standing Council for LIC Housing Finance Limited submit that since the LIC Housing Finance Limited is not a state or other authority within the meaning of under Article 12 of the Constitution of India, same is not amenable to jurisdictions. Therefore, Lordship, I have opposed the labor court to challenging my transfer order.
Yes, madam, why didn't you approach the cat? Cat? You could have approached the cat also. Tell me, why not? Because cat doesn't have jurisdiction. You should have approached the civil court and got an order for stay, injunction. Then
Lordship, actually what happened, there is a, actually, Lordship, my punishment is, my transfer is not for administrative exigency. It is for.
Madam, I'm not going to look into that, whether the transfer is right or wrong. No, that is not the subject matter. The subject matter is as to whether the industrial tribunal or the labor court can adjudicate in pursuance to the provisions of section 2A or section 33 or 33(3)(a)(b) a transfer order.
Lordship,
The answer is no.
in honorable labor court, I am not only go for against my transfer order because there are several mental harassment in official
So
Obviously,
mental harassment, physical
scheming.
assault, all these things will come before the civil court.
yes, Lordship.
So better go to the civil court. Mr. Datta, matter is over.
Kindly, senior's presence is necessary.
Why do you need Mr. K. N. Chaudhary?
Lordship, after 10 minutes, Lordship, he is on legs in court 7, Lordship, or court 5, Lordship. Only 10 minutes, Lordship.
Well, as we are allowing your repetition, let us hear Mr. K. N. Chaudhary at 1 o'clock.
Yes.
1 o'clock.
One.
You tell him that I am also skipping my lunch. He should also skip his lunch.
For your lordships, the Rajasthan transport will go to the point of.
Do you have any doubt that this court has not understood section 2A?
Not that, statutory provision is buttressed by a law. The flag I have given, paragraph 20.
Best is the civil court. Civil court.
27.
Yes.
My lord, I have received instruction in this matter. I will file an affidavit. I have received the instruction, my lord. And
Matter?
otherwise, my lord, if even my lord, I have checked one thing, my lord. This is not even maintainable, my lord. His appointment, my lord. When his
You had
father
a
died,
compassionate appointment.
when his father died, he was a minor. So, my lord,
That thought, first of all,
my lord.
no government council seeks for an accommodation in a matter of compassionate appointment before me. The reason is they don't need to say anything.
No, my lord. I am always before your lordship, my lord. I'm just pointing out that two things, my lord.
When did your father die?
2008 lordship.
Hmm?
Then during the lordship, I applied immediately lordship.
So,
Lordship, there's lordship, they kept pending lordship.
huh?
They kept pending lordship for 7 years lordship.
So what?
This is their fault lordship. And even lordship, the rejection order lordship is absolutely wrong lordship.
What is the revision?
It is
Huh?
It is said that I applied after 9 years. That is wrong lordship. Actually, I applied immediately lordship, I have proof lordship.
What?
There also,
Where is the rejection order?
page 62 lordship. It is lordship actually it is page 2018 lordship, but I lordship.
Pisul Nursery. Pisul Nursery. The application was submitted on 28/7/2007 by the government servant died on so and so. Application was submitted after gap of a year after the death of Sunila so and so. Iman, the application is back now cannot be considered due to delay in submission. No, wrong. Understood. But why should we give it? It is not a right. Where is the right? Show me a right. That you have a right. Yes, it is wrong. But is it a right? Compassionate appointment is for immediate succor. But look here, this blade runner had died. So we do one thing, we give a job to somebody so that this particular person can, this family can sustain. That's all.
That's all.
they are to lordship immediately keep the relief lordship, but if they kept pending lordship, there is not that my case lordship, I did not approach them immediately lordship. I approached them lordship immediately. They kept pending lordship. Even earlier lordship, I also filed an expedition lordship. Then also High Court also lordship given some observation to decide my case lordship.
But tell me,
Yeah.
no, tell me. As of now, there is no case of immediate succor giving you immediate relief. You have survived the last 18 years. How?
I have stated in my petition lordship, with suffers lordship at this state also lordship, I have made a loan lordship. And
No, understood. You survived.
that can lordship we are living as a lordship only surviving this. That means not lordship, I am just passing past this year. So that my pollution is good lordship, is not lordship.
Huh?
Still our pollution is very bad lordship, we cannot lordship. Now, our position is that lordship, we cannot declare still before the public lordship as a man lordship. One loan after loan lordship,
Where are the loans you have taken?
but that still I bad lordship, but
Huh? Where are the loans? Or you, Mr. Hawk, knows more than what the petitioner has recited in the petition? Tell me, something must be there somewhere. Dismiss.
lordship,
Dismissed.
then also lordship, after the again we approach them lordship, they again passed an order lordship to submit our proposal lordship, resubmit our proposal lordship. That is also not they have done. Resubmit, they wanted to resubmit lordship. Can you see this?
Mr. Hawk, I am not going to do anything to this thing. Whenever a matter comes before the compassionate appointment, the person out there normally withdraws the petition before me passing an order and says that better try my luck with them.
No, we are not.
See, now he doesn't want to file.
No, my lord, I was on it, my lord. That, my lord, the thing is that the matter is settled. But this is the settled position of law, my lord. He was a minor.
Minor.
When father died, so my lord cannot claim a compassionate appointment when he attains majority. That is settled position of law. I have the judgment, my lord. He is 33 now. In 2025, 2008, he was 16, 15 plus.
Next 6 months, compassionate appointment, bad days.
My lord, this is the settled position of law. I need not. This is the settled position of law, my lord. I just checked.
Only a person is lordship is survived for a year lordship, that doesn't mean that he can survive for future also lordship. Because
No, therefore, my question is when there is no necessity of any immediate succor, your claim now is like a right. That means they had a policy to give this benefit. That policy also contained the term. That is principle number 12 or 10.
10, my lord.
That if an application is pending for more than 2 years, it will say that it has become infructuous. Not dismissed. Dismissed. Hey, order pass kori. এইটো কালি যোনটো প্ৰতিপক যোনটো দিছো লাষ্টতো the reason may be wrong, but however this court is not inclined to give any relief in the circumstance of the present case, taking into account that the petitioner had been able to survive 18 years after the death of the father. প্ৰতিপৰ যোনটো আমাৰ এই কেছটো আছিল ইয়াৰ নামটো কি B. Bukastor at the cases. Yes, what is this?
not filed for the order dated 12/6/2024.
Where is it?
Lordship, please lordship, annexer is lordship. 13 lordship. Harningla lordship, 31 lordship, Begum 5 lordship.
A notice? আমার এখন অফিস R1 file affidavit 2-3 it was yeah. Hello. Nobody has appeared for the Guwahati Municipal Corporation Commissioner. No, very well, we asked her to be present. No, the direction is only given to the commissioner. Why you are making all other people a party unnecessarily? And a commissioner is not represented, although they have filed wakalatnama. So therefore, we take away his right to appear through a council. Name has not been shown, somebody's. In a list, naam dekhaiche na. Respondent the ukila.
Lordship, paragraph 5 says that the lordship order.
Hello, none appears. I hope. This is an application file alleging willful and deliberate violation to the order dated 12/6/2024, passed in WPC number 2992/2024, whereby a direction was issued to the Commissioner GMC to dispose of the representation if not already disposed of, and a copy thereof be served on the petitioner within a period of 1 month from the date the certified copy of the order is served upon the Commissioner GMC. It is the further case of the petitioner that the said order was duly served upon the Commissioner GMC on 24/6/2024, but till date, the respondent authority, the respondent number 1 have not taken any steps in that regard. Full-stop. It is seen that this court issued notice on 7/3/2025, and the service and the office note reveals that the respondent number 1 has already entered appearance through the councils, but there is no affidavit filed as to whether the order dated 12/4/2026/2024 have been complied with or not. Considering the above, as none has appeared on behalf of the respondent number 1, this court dispenses with this court directs the Commissioner GMC to be present. Why haven't you complied?
What had happened is,
Have you complied or not?
it had been complied to the extent that the subsidy allowance had been given. And subsidy allowance had been given, and the pension are being released. September 25, the pension are released. Only the gratuity part and the other parts, leave encashment, that has not been released because the amount has not come from the government.
Interest?
That moment that comes, it will be released.
The moment is come, but his entitlement is from the date when he is retired.
Yeah, my lord. But that has not been released the government, my lord.
Why haven't you filed your affidavit? Where is your order? Representation order? What is your order?
The respondent 1 has been transferred. Some person has joined. So lordship will allow me some time. I'll really please the present government, my lord. I'll file my affidavit. That is the fact, my lord, all that the subsidy allowance has been given long back. Because I can hand over, but the brief is not with me.
But do you say that he has been given subsistence allowance?
3 lakh amount has already been used. I have it, the document.
And
I have the document.
where is it?
Well, lots will take it after some time. I'll hand it over.
Okay, 110. 110.
Lordship.
Yes.
I have it. Lordship.
1 o'clock, I am hearing Mr. K.N. Chaudhary for 10 minutes in another matter. Then 10 o'clock, 110, your matter.
Lord.
Yes, Mr. Dasgupta. Your issue is whether if there is no standing order, then there is no age. That is his case. And more particularly, your terms, his terms of appointment also did not stipulate the age. On the other hand, you have terminated him. You not terminated, you have superannuated him, taking into account that he has, on the basis of the materials on record, you found that he's 73 years old. Now, how do we resolve this situation? Without the standing order, without the term, can a person be retired on the basis of a draft standing order which did not come into force? Or can we import it from the central government standing orders if the appropriate government have not framed the standing orders?
Here the retirement age was fixed by the Supreme Court in at the age of 60.
Age of retirement or super company applying the section 10 of the
Age of retirement was stipulated. Subsequently, age of retirement was stipulated at 8 years.
Where is that? Now, did the Supreme Court incorporate it from somewhere else in absence of a standing order? Did the Supreme Court bring the central standing orders when the appropriate government, the state government did not have a standing order? We are with that situation. The state government did not have a standing order, or that standing order which was there did not have an age.
In the retirement age. This is the case.
And your own standing orders do not have an age.
Here, same thing.
The terms of employment also doesn't have an age. So how do we do it? As per them, they were only 47 years, huh?
We can work.
59 years.
You have 59 years. One more year.
Yeah, 1 more year. 1 more year. One is 59, one is 58.
One is 58 and one is 59.
8 years, 10 months.
Now, can we take some precedence from the fact that in your company, you otherwise follow 60 years somewhere? If we take up that precedence also, we can do something. But that is a case of evidence. Where? This is the point. That is why I wanted to have this matter today. Because it's a 2011 matter, it doesn't look nice. Guwahati High Court 2011 matter pending and that too high parted.
This call, it just become region. But all these cases, why is T9 through LNJ period of 5 years, it come after 50. Enough.
Second, I have given a commitment to Mr. Kohli to take up his matters. That is why at 1 o'clock I am taking up Mr. K. Chaudhary's matter. 1:10 I am taking up somebody else's matter. You give the judgments. Let me have a look. We have it again on next Tuesday. How many matters are there next Tuesday? Given matter also. Okay, we'll have it on next Tuesday. To him. And you have any judgments, you give it to him.
Yes.
We'll have a look at it as to how to tackle this situation. There might be one thing, that is what it has just come up from my mind, that if it is formed as a precedence, or you have been following in your. Oh, very good. So if that is so, then if you can so, then I have to remand the matter back again. Only no, only on the question of that. Ah. Then I'll have to pay the.
This case here, retirement age should be fixed at 60.
Six.
So your lordship can discuss those judgment. And
Which one? Or these judgments? Okay, I will look at it.
The idea which your lordship conceived.
No, we can have it, but you then they will be entitled to almost a year's back wages or something. It's illegal termination. Only 1 year, some wages have to be paid and finish it off. Yeah, only 1 year. 1 year it is there. And why would you be agreeable for taking 1 year wage and finish it off?
Oh, yes, that will be better. Yes, my lord,
Huh?
that can be done, my lord. That should be better.
If you can agree for that, the matter ends unnecessary, because you see, this is I tried my best to get this from the state government, the rules. Now, in view of the code of wages coming in again, the problem has, and the code of, and the industrial, standing orders 2024 having been given effect to, the earlier has already gone for a 6. So now whatever it is done has to be done post facto. So at that point of time when the dispute arose, then was a different thing. So if you are agreeable for this 1 year wage and give it up and then they pay this matter over, then can we keep, you just ask your clients, how many witnesses, how many persons are there?
There are 2 persons. Right?
Two.
In this case, actually 3 persons involved. One has already instated.
So as regards these 2 persons,
persons.
you just find out as to whether they will be agreeable for 1 month salary, 1 year salary, which as back wages they will be given. And if they are agreeable for that, let us then post it on 10th. Oh, no, let's have it on 3rd. You just get your instructions then I'll post it again for filing a joint affidavit if you are agreeable. Otherwise, we'll take it up for final disposal. Huh? Huh. Yeah, helping you is a different thing. But the thing is, this will have a lot of, there's no problem in delivering a judgment, but there are certain problems out here. It's in a complete gray area.
2011.
So therefore, I think we need to finish it off. We'll have it on 3rd. You get your instructions. Let's see how it works. Chalo. The matter having been further heard, but not completed, hearing being not completed, the matter be again taken up on 3rd of February 2026 and shown at the top of the list. Get your instructions. You give. You need your judgment. Your judgment you don't require for that. Because your thing is, if there is nothing out there, no stipulation out there, you cannot be thrown out. Where is Mr. K.N. Chaudhary? Then also he has not come.
No, Chip is coming on the way, Lordship.
Now, are you telling me that he is sitting out there? Yeah, matter. I think no other court is sitting, taking into account that your senior counsel is so busy, he doesn't have time. I've given him a time at a time when no courts are sitting.
I'm so sorry.
No, Mr. Chaudhary, I gave you the time because then you may not have the problem with other courts.
I'm so sorry. My lord, here in this case, our view is simple, my lord. This was an application under section 2A, read with section 33 and 33A. My lord, I was a cluster head in Guwahati. When I was sent to my lord Kolkata, I was sent as a my lord credit manager. Credit manager reports to cluster head. So it was a case of demotion. So therefore, it's a case of violation of condition of service. That is how we filed the application before the labor court.
Now, my lord, I am not a managerial person. I do not have any such right.
No, but we are not going to go into as to whether you are a workman or not. The question is, how do you bring your case under 2A?
The 2A, my lord, maybe it was a wrong, insertion, my lord. Basically, it's an application under 33, my lord.
33 also won't come in. You have to go before the civil court.
CAT.
Civil court.
Or maybe civil court.
Civil court.
LIC
This is the right forum. Because you see, this is not a forum. That is why I asked her, why not to CAT? The reason why I've asked is because CAT also doesn't have jurisdiction.
No, if to CAT had to come under CAT, I think.
No, CAT wouldn't have, because taking into account the civil procedure, they don't come.
No, that notification is not there.
No, this is LIC.
Or Lordship will give us 10 days time below status quo as on today will file, go to civil court.
Status quo is there or not, it is nothing
there,
out there. How they, when I'm dismissing the entire
In the
thing-
in the IA, there is an order. For a period of 10 days below status quo can be maintained, we'll go there below.
No, status quo is totally a confusing term. Now, your lordship has seen, the level court's order has been stayed by dishonorable court. So this is the end of the matter.
No, the second order has not been stayed.
Since the matter has been deferred to be listed, let status quo be maintained till the next stage. The status quo is of 8/12.
That was extended.
No, no, it's okay. On 8/12, a status quo order is passed. Status quo of what?
No, my lord, what had happened? First, I was sent to my lord Kolkata because there was an stay order by the labor court. Therefore, they modified the order. That means the first order is no longer there. They modified the order by bringing me back to Guwahati as a credit manager. Then I went to CAT, my lord, that there is a stay order. That order has not been there.
CAT?
Yes, sorry, labor court. Labor court. There is a stay order.
Of? In the labor
Labor
court.
court, yes.
So then.
And that order has not been touched by anybody.
So I am going to set aside the entire proceedings is.
No, all that I'm saying is, my lord, lordship will let us parties maintain status quo for a week or 10 days. We'll go to civil court, my lord. That's a debatable issue, my lord. I am also not joining issues on that, whether labor court has jurisdiction or not. So therefore, my lord, but I must have some, my lord, remedy, my lord. There is a wrong.
Okay, let us give him 10 days time.
Yes.
Standing for what? That's the question.
No, the status quo, which is as on date, shall be maintained till date.
Ah.
Till, as regards the service of the petitioner shall be maintained, but this status quo shall not influence any other court, any other forum that this court has considered it on merit.
No. Yes.
I think that is a fair order
Yes,
which can be passed. And as regards the writ petition out there, I'm allowing your writ petitions. They're holding it to be a nullity out there, their proceedings to be a nullity. Quash that. But as there is a year, so that now the avenue available is before the civil court, so they may approach that. So they may approach there, but this court, as there is some protection, this protection shall only remain till for 10 days, and the court before the forum before whom the petitioner shall approach under no circumstances shall be influenced by the status quo or disorder has been passed. No, they shall decide it. Hello, repetition allowed. I closed. I'll pass the order. You'll get it in. Today I'll pass the order. You'll get it by tomorrow.
Milan. Deeply.
Yes, the next matter, Mr. Bora.
Subsistence allowances are released on 23/4/2025, my lord.
So you have paid some 3 lakhs.
3,92,000 out, this is the subsistence allowance.
Hmm.
And my lord, there is another paper, my lord, single paper, my lord. This is the calculation, his pension has been calculated. And he had received the pension for the month of September 2025. That's even serial number 51. Her name is there. This is the family pension. Wow, her husband was working.
No, the only question is as regards the representation, have you disposed it of or not?
But that instruction, I don't have it, my lord, today. My lord, only thing is that this
That is not the question. I'm not, this is the direction.
direction represent my lord.
There is no direction to pay or anything. Only direction is as to whether the representation has been considered or not.
I will-
List this matter again on 2nd of February 2025, 26, on which date Mr. Esbora, who represents the respondent number 1, shall apprise as to whether the direction passed by the learned coordinate bench dated 12/6/2024 in WPC number 2992/2024 for disposal of the representation by a reasoned order have been complied with or not. I'm not on orders, and if you have not, we'll have it on 6th. 6th. By that time, if you have not passed the order, pass the order.
Lordship.
That is why I'm fixing it on 6, so that I drop the contempt.
কিমান সময় চলে ফুলবোৰ? অলপ টাইম ল'ব। তারপরে কি
তাৰপিছত কেটেগৰী নেকি?
আছে আছে দুটা নাই নে এটাই আছে?
আৰু এটা সৰুটা আছে।
31-32 একজনমান দিব নেকি? দিয়ক 31-32 এইবাৰ জেনেৰেল সিৰিজ মেটাৰ আছে এইবিলাক কোৰ্স
ফাইলটো আহিব দিয়ক। চেনেটৰ আছে।
Without making a submission, Lordship, just to, and we will of course bow down to how Lordship would like to hear it, because there is the batch of petitions and then there are the vacation of stay applications, which the state has filed. Now, wide order dated 7th of April. Lordship would be pleased to come.
Yeah.
7th of April, Lordship, this court broadly had held that we could hear the main matter itself, because ultimately a large part of the arguments in the interlocutory applications for vacation of stay would be subsumed into the arguments of the main matter. Now, if Lordship may just come to the second last paragraph, Lordship, on the second page, page 3. All the writ petitions are directed to be listed for final hearing and disposal as fixed items on 29/5/23, with the understanding that neither party will seek adjournment on that day. If necessary, hearing will continue on a day-to-day. And then, Lordship, in the last paragraph, it says, however, taking note of the submissions of Mr. Kohli, that contempt petitions are pending against the officials, he is given liberty to suitably mention the matters as and when the contempt cases are listed before the court. I may point out that no contempt case, to my understanding, is listed today. Not today. So therefore, Lordship, on the next date, the court couldn't hear it. Just as Suman Sham, the news had come, he would be traveling to Bombay. Then, Lordship, on 31st of July, there was a personal difficulty with one of the senior advocates on the petitioner side. So it was fixed, Lordship. And two categories of state were created. A category A, so that the cases were segregated in those who have challenged the parallel proceedings of the DP and the criminal matters, and those who have challenged the one-man commission report and along with it, the question of the non-compliance of 8B and 8C, and also the parallel proceedings. So then we gave a note to the court just to segregate it for information, which are only challenging the parallel proceedings, which are challenging both lordship. Then lordship, on 30, it could not be heard in August, September, in October, lordship, we, an application came from the other side that you need to purge contempt before the interlocutory applications are heard, which is what my learned friend has filed. And then lordship, on the 12th, on the 2nd of December, there was a medical exigency, so we are here today. This was the just in terms of court proceedings. My request, of course, lordship is, would lordship like to hear the full matter? We are before.
I'll hear the whole matter. Now let us take, there are two sets.
With my lord's permission, may I address my lord?
No, wait. There are two sets, as I could see from the list. First is some notification being a challenge because that's the heading. And the second is something to do with the continuation of departmental and criminal proceedings simultaneously.
Take out note.
Let's first take up the first one, the first set, which is the lead matter.
I beg to appeal.
Which one?
The lead matter your lordships will treat matter item 34.
Which name?
Priyanka Degdal.
Okay. Let's argue.
We are also treating that as our lead. I'm grateful for that.
My friend, my lord, placed a few orders.
No, it's okay. Let's argue the matter. What is the case about?
Items 33 to 53 minutes. And 55 and 57 minutes. 55 and 57. I appear minutes for the writ petitioners. The writ petitioners were selected minutes in the competitive exam of 2013. They joined their respective posts and they were carrying out their duties in the post which they were given, and they were posted regular postings. They were now what happens is this on 8 July 2019, a one-man commission of inquiry is set up by the state government. Here's the notification. The one-man commission starts the inquiry, giving a lordship the labor and during the inquiry, the one-man commission inquires into the conduct of the petitions. So the one-man commission issues a notice directing the registry, the secretary of the commission, to notify the issue a notice to the writ petitioners to file the reply. Now, the reply is filed before the commission. After that, thing is heard from the commission. And public domain, the report we get to know, the report of the one-man commission, was to the government of Assam, and based on the report and the recommendations of the one-man commission of inquiry, the petitioners are issued a show-cause notice for departmental proceedings, and they are suspended. The services are suspended with immediate on 30th November 2023. Now, the suspension order and the show-cause notice is the subject matter of challenge before your lordships in the writ petition. This honorable court, single judge, on 6th of December 2024, if your lordships have that order, stayed the show-cause notice and the suspension order. 6th December 2024. My lords, has that?
Where is the so-called notice?
The show-cause notice your lordships will find is at page 46. And it's entirely premised, my lord. If that it has been reported by the one-man commission of justice so anomalies and malpractices resorted to for the selection of candidates with money and extraneous considerations by the APSC, headed by the then chairman Sri Rakesh Kumar Paul, for conducting the combined competitive examination. That you are a beneficiary of that. that you have got recommendations by the APSC appointed by enhancement of your original scope marks in final tabulation check. Hence, your recruitment for government service on the basis of recommendation is illegal. You secured your job, a job for which you were not qualified. You are therefore charged with misconduct, getting it for illegal means and hence not fit for government service. Then different 40. Wait, 48 a lordship said, madam.
So the report of the one-man committee of Justice B.K. Sharma,
Yes,
I think some extract,
yes.
they have produced some extract. Because at page 49, you see, they mention as extract.
Three. That's a letter, my lords.
So the entire report is not there,
Not.
but only the extract is being given.
Yes. Secondly, my lord, now please alongside this, my lords.
Now, first of all, this is a report made under the Commission of Inquiry Act.
Inquiries Act, yes, I'm grateful, man.
So whether that report has been accepted by the Assembly?
Yes, it was placed much later, my lord. Last year in February 2025.
Hmm.
The report was of 2023. The report is placed, my lord, in 2025. It was laid before the Assembly last year.
Then, along with the action taken report has been mentioned or not?
Not extended.
Which is, let's see the Commission of Inquiry Act, Section
Yes,
5.
I'm grateful, my lord. But before that, if your lordships come to that, my lord, just one other, and since your lordships are on the act itself. Our case, my lords, is,
No, Mr. Chaudhary, why I'm putting this question is,
yes,
around 2-3 days back, there was a writ petition filed before this court seeking direction upon the government to take action on the basis of this B.K. Sharma's inquiry report.
inquiry report. Yes, my lord.
I have not issued notice in that matter, taking into account that there is no compliance with Section 5.4.
I'm grateful.
So without that report having any legal standing,
Yes,
can
sir.
it be the basis of a show cause proceedings?
Yes, grateful. That's one submission. But the other submission, the lordships will appreciate, since your lordships is on the Commission of Inquiry Act, is when the commission, my lords, inquires into the conduct of a person, or if the recommendations by the commission is going to impact on the reputation of a person, then on the 8B of the Commission of Inquiry Act, the lordship knows, my lords, a notice has to be issued to that person. He has to be made to appear before the commission and lead evidence in his or her defense. He will be allowed, my lords, to have a legal practitioner of his choice under 8C. And, my lords, cross-examine the witnesses. Now, accept that notice which came from the commission to file a reply. After the reply, nothing is done. So
But
my
ha-
respectful sir,
Have you challenged the Commission of Inquiry
Yes.
report? Yeah?
yes, just have my prayer, my lords. My prayer is illegal, null and void, and I will make good that submission, my lords.
Yeah.
Direction be not issued, declaring, adjudging the proceedings before the justice so-and-so inquiry relating to the affairs of APSC and culminating in the ex parte report containing ex parte observations, binding recommendations. Insofar as it concerns the petitioner hearing as illegal in gross violation of the rights and safeguards conferred by Section 8B and 8C and the fundamental rights of the petitioner granted on the court. Second prayer, please see, my lords. Now, my lords,
So your, therefore, first challenge is pertaining to the
Yes.
the recommendations made by the Commission of
yes,
Inquiry.
and my submission is, my lords, it's a very fine legal point, my lords,
Hmm.
which is a settled position in law.
Hmm.
That if you violate 8B, the report is void. The recommendations there my lords, cannot be acted upon. Just have 8B, my lords. Law is well settled, my lords. The lordships are aware, my lords. There is a judgment of Justice Kiran Bedi, my lords, versus the Commission of Inquiry. This is a 8B. Person likely to be prejudicially affected to be heard. If at any stage of the inquiry, the commission considers it necessary to inquire into the conduct of any person, or is of the opinion that the reputation of any person is likely prejudicially affected by the inquiry, the commission shall give way to that person. Please mark, my lords.
a reasonable opportunity heard in the inquiry and to produce the evidence. These are our evidence, not defense. Provided that nothing in this section shall apply when the credit of a witness has been impaired. Also have 8C. Right of cross-examination and representation by legal practitioner. The appropriate government, this is the typing particularly in all that. It should be explained. Every person referred to in section 8B and with the permission of the commission, any other person whose evidence is recorded by the commission may cross-examine a witness other than a witness produced by it or him, may address the commission, may be represented practitioner or with the permission of the commission by any other person. So, my lords, the day, my lords, the commission issues me the notice. That is the day, my lord, when the commission was inquiring into the conduct of the request. So, 8B protection, my lord, these are statutory safeguards, my lords, is available to the petitioner. This has been flouted. And if this 8B and 8C is flouted, in my respectful sub, the report is void. The recommendations pertaining thereto are not binding.
So you submitted your written statement pursuant to this notice
Yes.
dated 13/8.
Yes, yes. I filed my reply. After that, my lord, nothing is heard from the commission. So 8B, your lordships have seen, my lord. It is the commission, my lord, who has to give me that right, that safeguard. And law is settled, my lord. I will place those decisions which says, my lord, if you do not comply with 8B and 8C, the report is void.
Now, Mr. Chaudhary, what do you say about the procedure at Rule 5 of the Commission of Inquiry, the central rules? We have a state rules also?
No. And Yes, the procedure of inquiry. A commission may sit in public or in private, provided a commission shall sit in private on the request being made by the central government in the behalf. A commission shall, as soon as may be after the appointment, issue a notice to every person who in his opinion, this is a notice under section 5, my lords. Public notice is issued. Then, my lords, issue a notification to be published in such manner as it may deem fit.
No, no, issue a notice to every person. Which is the notice which have been issued to you? Yes.
Is at the initiation of the inquiry, my lords. Once the commission has been appointed, well, the commission issues a notice.
No, 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 kindly read 2A, 5-2A.
Yes.
Issue notice to every person who in its opinion should be given an opportunity of being heard in
Yes.
the inquiry to furnish to the commission a statement relating to such matters as may be specified in the notice.
Yes.
Now, if we see this particular notice which was issued on 13/8/2021,
Yes, my lords.
you'll see whereas the government in the political so-and-so, and whereas during the course of the inquiry, the following malpractices and prima facie found against you as revealed from so-and-so, these are the whatever has been given.
Yes.
Now, therefore, in the background of AI, prima facie circumstances, prima facie necessarily arises as to how huge anomalies and malpractice could happen in so-and-so. You are therefore asked to respond to above anomalies by way of a written statement. If you are desirous of seeing the particular answer script, FSL and so showing the apparent variation, you may do so by visiting the office of the commission. Your written response should reach on 20 year, failing which it shall be presumed they have nothing. So
Yes.
this seems to be done in terms with 5-2A.
No.
Yes.
Just 5-2A, my lords, is a notice which is asking the general public that if you have anything to say on the terms of reference of the commission, please come forward and give your view. That's 5-2, my lords, will have it again. Require any person subject to any privilege which may be claimed by that person under the law to furnish information on such matters or as in the opinion of the commission may be useful for or relevant to the subject matter of the inquiry, and any person so required shall be deemed to bound to furnish such information within the meaning of 176 and 177.
So what is this notice this?
It's actually, this is where the commission decided to inquire into the conduct of the writ petitioners. It's essentially a notice under 8B. If they follow 8B,
So that means you mean to say there is no procedure for issuance of this notice?
this which is issued is on the ground that he was inquiring that some material came against the writ petitioners, which required the commission to inquire into the conduct of the writ petitioner. Right, my lords? So that notice which is issued, essentially, my lords, the day when he decides to issue notice.
But the rule 5-2A says a
Yes.
commission soon after its appointment, issue a notice to every person.
Yes.
Listen, who in its opinion should be given an opportunity of being heard. The opportunity of being heard is in 8A.
Yes, sir. Yes.
So
Yes.
this is a notice under 8A. But the procedure is stipulated in 5-2A.
Notice is not the 8A.
Yes.
8A, my lords, is inquiry not interrupted by reason of vacancy or change in the constitution.
No.
It
You
is.
see-
It should be, my lord, first have 5-2.
No, kindly come to 8B.
Yes. 8B is, my lord,
If at any stage
any
of the
stage
inquiry,
of the inquiry,
the commission considers it necessary to inquire into the conduct of any
any
person,
which-
or is of the opinion that the reputation of any person is likely to be prejudicially affected by the inquiry, the commission shall give to the person a reasonable opportunity of being heard in the inquiry and
to-
produce evidence
So,
in
my lord,
this
this
defense.
is- this
Now
is-
kindly see here, again,
Rule-
5-2A. A commission, so therefore it is not being only segregated only to that particular thing,
Yes.
anything.
Yes.
5-2, a commission shall as soon as may be after its appointment issue a notice to every person who in its opinion
Yes.
should be given an opportunity of being heard.
Yes.
Now 8P says that this particular thing upon whose reputation is being looked into, he has to be heard.
Yes.
now to say, to furnish to the commission a statement relating to such matters as may be specified in the notice.
Yes,
Now here he is asking that these are the things which we have found. So under such circumstances, what do you have to state? Now kindly see here. Issue notification is B. This is to everybody. Every statement furnished under clause 2A shall be accompanied by an affidavit in support of the facts set out in the statement sworn by the person furnishing the statement.
Yes.
Every person furnishing a statement under clause 2A shall also furnish to the commission along with the statement a list of documents, if any, on which he proposes to rely and forward to the commission wherever practicable the originals or true copies of such documents as may be in his possession or control, and shall state the name and address of the person from whom the remaining documents may be obtained. A commission shall examine all statements furnished to it under clause B of rule 2A. Now 2B is different again.
Yes.
Issue notification to publish. So this is asking everybody a statement relating to the matters as may be stated.
Yes.
2B. And if after such examination the commission considers it necessary to record evidence, it shall first record the evidence, if any, produced by the central government.
Yes.
Here it would be the state government.
Yes.
And may thereafter record evidence in such order as it may deem fit.
Yes.
The evidence of any person who has furnished the statement under 2A
Yes.
and whose evidence the commission, having regard to the statement, considers relevant for the purpose of the inquiry.
Yes.
Evidence of any person whose evidence in the opinion of the commission is relevant to the inquiry.
Yes.
So therefore, here you have replied, submitted a written statement on 23/8/2000 so and so,
Yes, madam.
and
Thereafter, nothing is heard.
so thereupon they have not, the commission did not intimate you anything.
Anything. I was, my lords, the commission, it was incumbent on the commission to give the safeguards under 8B and 8C.
So in the records of the commission, how did the commissioner take into account the reply you have submitted? Have you looked into that?
No, my lords, I'll tell you, the report is not on record. There are 4 orders of the court directing the state government to file the report. The report, as I address your lordships, is not being filed by the state. Now, my lords, the issue is this. The issue is, my lords, the day, my lords, the commission decided to inquire into the conduct of the writ petitioners, he records it in an order and directs the secretariat to issue me a notice. Right, my lords? Actually, my lords, when he was actually proceeding under 8B, but the 8B safeguards have been flouted by the commission. Admittedly, I was not called before the commission. Admittedly, I was not allowed to be represented before the commission. Admittedly, my lords, I was not allowed to cross-examine the witnesses. So, well, these safeguards, my lords, have placed the law, are, my lords, court has said, my lords, that these safeguards are a valuable safeguards provided to an 8B notice under the Act. And if it is flouted, the consequence is this, my lords, that the report is void, it is not binding, and any consequential act taken pursuant to the report is bad. That's the LK Advani judgment, my lords.
Or can it be also rephrased in this manner?
Yes.
That the Commission of Inquiry issued the notice to you on 13/8/2021 asking for your statement.
Yes.
You submitted the statement in terms with section 5(2)(a). You submitted your statement. Thereupon, the non-intimation about the future course of action
Yes.
took away your right to ask the commission that you want to cross-examine it, because you need to seek the permission of the inquiry, permission of the commission for the purpose of cross-examination. That's the mandate of 8C.
No, my lords.
Yes. You want this.
A.
Every person referred to in 8B.
Yes.
That is you.
Yes.
And with the permission of the commission.
Yes. Any other
person whose
Yes.
evidence is recorded by the commissioner.
Well, sir, any other person, that second will not cover an 8B notice. So 8B notice, he has a matter of right, has a right to
May
cross-examine the witness.
cross-examine a witness
Other than the
other than
witness
the
produced by him,
produced by him.
may address the commission and may be represented before the commission by legal practitioner or with the permission of the commission by any other person. So well, if legal practice, I have a right to engage. If I want any other person, that person has to be with the permission of the commission.
But what do you say about section 4? Section 3.4.
Appointment of commission, yes, ma'am.
3.4. What do you say about this?
Requires the appropriate government shall cause to be laid before each house of parliament, or in the case may be the legislature of the state, the report, if any, of the commission on the inquiry made by the commission on the subsection 1, together with the memorandum of the action taken thereon, within the period of 6 months of the submission of the report by the commission to the appropriate government. So it requires the government to lay it on the floor of the house along with the ATR, action taken report. So what action they are going to take, that along with the ATR, the report has to be played. On this point, my lord, because I had looked into it, what happens if you don't comply? Because when we first moved the court, my lord, that point of time, the report was not laid before that. Report of 2023, laid in 2025.
But with the was it done with the action taken report?
I think so. With the action taken. We'll have to find that out. We have no, that my friend has to say.
Yes, Mr. Kohli.
In fact, I'm going to check on that only with the action taken report. But just to add to this lordship, there were 2 batches. 30 batch, the 14. Once it was completed in both, it was laid in the House of Assembly.
Now, did you submit the action taken report?
That I will just read, again, the instructions are.
You have not got it.
I'm not aware. I need to find out
Because
specifically the action.
without the action taken report,
cannot.
This inquiry has no legs to stand. The report has no legs to stand.
On which just to let lordship know, that there will be 2 parts to it. It is that minute that there is an arrest, then the disciplinary proceeding under 6 also starts. There are 2 legs, but I'm not getting into the arguments. On the action taken report, I have to just, while the hearing is on, get the.
No,
I
you
would
were
expect
saying-
it would have been late because the procedure would have been. I just want to get a copy.
Regarding the procedure, because the report on its own has no value
No way.
unless there is an action taken report submitted.
In fact, it is not a court. It is merely for the mind of the government. I mean, that is the settled law. In fact, there is no dispute with what my learned friend is saying. That is the settled law.
It only gives certain recommendations to the government. The government may accept or not. That's a different aspect of the matter. But it has, but to gain a legal status to that report, it has to be laid before the legislature along with the action taken report. And without that, and if it is not done, your very action taken on the basis of a report which has no otherwise no legal standing has no value.
Specific instruction is one below.
Mr. Kohli, I am putting this question because 2-3 days back, a writ petition was filed before me saying that why the government is not putting the action taken report. That was the writ petition. Therefore, I am saying, without the action taken report being not there, my question, therefore, my dilemma on that day was, can I issue a writ for that? Because it is absolutely within the domain of, it's a
state.
recommendation.
Yes.
It is absolutely within the domain of the government to take action or not.
May accept, may not accept.
May not accept.
Yes.
So therefore, if they don't give it and don't put it within a period of 6 months, which is the mandate, what is the value of the report?
So
And if the
that
value
was
of the report doesn't have it, then can you make it a basis of a disciplinary proceedings? Yes, the truth may be, yes, these are things which may be there, but that's the law. You have to follow it.
I'll of course go to my horses on that second leg of it because our entire argument will also be the charge sheet in which.
But that's not, if
That's
it
not-
is the charge sheet, then charge sheet is not a list of documents.
Yes.
Neither there is mentioned. You have to again
Yes,
rework it. You have still time.
Of course, Lordship, today making this, I'm getting the instruction.
If you are saying that your other leg is the charge sheet, then we can very well allow this repetition, giving you liberty to go ahead
Yes.
with the charge sheet.
So Lordship,
It will act faster.
Under the disciplinary rules, Lordship, 6(1)(c) clearly says that the minute an investigation takes place, at that time, you will suspend, they have challenged the suspension. So therefore.
No, suspension is another aspect. Suspension is another
therefore the
aspect.
challenge here, Lordship,
If
there
a
are two challenges.
if a proceedings is going on, if a proceedings of, in a criminal proceedings is going on, you want to suspend him, maybe because of tempering and all these things, you can keep out, but you have to continue having these review meetings every time and then do it. That is another aspect on the suspension. But the initiation of the disciplinary proceeding based upon a document which does not have legal legs to stand, matter finished. I think we can close it now.
If my friend is agreeing on the 8B part, Malaj, I see nothing, Malaj, it has to be allowed. Just
So
wait for that.
your Mr. Because you see, if we can go only on 3-4,
Yes.
as of now, nothing is there, so matter ends out there. Now, if we go into the case of 8B, then I have to say that the entire report is bad.
Yes.
Then we will have more cascading report. It means it becomes a big issue. I don't mind having an issue, but then also do you want that?
Well, it's,
Because of the fact that the one-man committee did not comply with 8B or 8C, or it
8B,
had,
8C.
you have issued the notice to him, he replied, and after his reply, you kept quiet.
Nothing is.
Or is it there on records? You are accessible with the records of the commission. Whether any action was taken by the commissioner to that effect that after his reply, the commissioner thought that no, we need not call him to give evidence. Then the question is another aspect of the matter.
On that, I can also just assist Lordship, that essentially, Lordship, they were all issued notice. Secondly, Lordship, they replied to the notice. 3, Lordship, they were given an opportunity to inspect the materials. And I would say that more than half of them inspected the material. The balance half did not. They chose not to inspect it. Now, that also, Lordship, on 8B, there is no pro forma. The very fact, so there are 2 judgments that we will come to. There is no pro forma per se of how an 8B notice should be. So as long as you are sending out a communication, in effect, our case is that this would fall into the domain of the compliance of 8B, because we have informed the whole idea that you will be prejudicially affected, which is what it is. And that in that this, you have an opportunity to respond. Those who have responded have. Now, there is another judgment, PR9 judgment, which says if you choose thereafter not to do anything, it is not only commission which needs to go and follow up with you and say, then in a sense, you have been informed that compliance has taken place. You have chosen not to come, and that cannot be held against the commission.
No, not to come is another thing. But to say that after submitting a reply, the commission does not intimate is another aspect.
Right. We will show those. Therefore, Lordship, it is not, they are bringing a case that I replied, which is a simplistic denial. That's getting implemented. I have replied, and then it is incumbent on the commission to thereafter do. It gives you the opportunity, or rather, the commission gives the opportunity for you to inspect a document. That inspection, for those who have inspected, gives them the right to say that I am prejudicially affected here. This is what I want in terms of concern, this is my thought. The examination, and this all has not been done by them. Now, those who choose, I know, wash their hands off and say, we wait for it. The commission will continue with its work. And the commission will not be held responsible for them to choose to stay away. Because it's not a court in terms of a court procedure. It's only a fact-finding mission. Clearly only to assist the government with its mind. That's it. And that's how commissions of inquiry have come. So that in a matter of public importance, somewhere or the other, the public is assured that this is not just the government alone which is doing it. In this case, it was a retired high. In some cases, it's a retired high. They have applied their mind. Then Lordship is the aspect of in rem and in persona, which is where the 8B and the rest, larger inquiry, Lordship, it may be a public issue. Then you send out notices to the public saying someone may have information. You are welcome to come and inform us and share with us that. That is a separate leg altogether. We are not concerned. In this particular case, Lordship, this is born out of several court proceedings finally. twice in 2019 because the APSC issue had come into the public domain. And of course, BIS got fired. Eventually, there were calls whether the examination should be cancelled or not cancelled. This was one leg of demands, if I may say, that the whole thing is vitiated. That led, which is not the issue today, but that led to the question that do you cancel the exam or do you then only identify the so-called tainted, segregate the taint from the chaff? That is the line of judgments that finally the Supreme Court has laid the law across. Teachers is one area where lordship it happens, perhaps a little more it has happened. So the law has settled that if you can identify grain from the chaff, then you don't cancel the whole exam because then there are a large number of people who are prejudiced, who have nothing to do with those who have manipulated the system in my decision. So that having been done, the government thereafter moved, which is the batch 1. Moved for dismissal. Those got challenged. Single judge of this court upheld the dismissal. DB has reversed it. There are certain directions. Government has complied with it. Fresh batch of petitions have come against the government issuing it. One set of petitioners have also gone to the Supreme Court and filed an SLP against the division benches judgment. So that is the first batch. This is the second batch. Now, in this sense, it's important to point out, which in this background becomes relevant, that in one of the petitioners in the first batch, the matter had come that there is a 9-page calculation sheet. That matter was before the learned division bench of the then Chief Justice. In that, an SIT eventually got created, and in which one of the points asked by the Honorable Court was, in its order, is what action is being taken at the identified beneficiaries, the others. So this lot is intricately linked to what was the investigation of the SIT thereafter. So there is a police investigation, Dibrugarh FIR, Bangagarh FIR, leads to the first batch dismissal. There is a 9-page tabulation sheet where the argument was taken, the investigation is not proper. The counter argument of the state was that the investigation is continuing. That 9-page tabulation sheet is the one which leads to supplementary charge sheets 12, 13, 14. Or 13, 14, 15.
Mr. Kohli,
Being filed.
Mr.
In
Kohli,
which
no, wait. You see, the issue involved here is very simple. Let us not complicate things. Here there is a challenge to Justice B.K. Sharma's report on 2 grounds. First, that there is no compliance to Section 8B and 8C. These are the 2 grounds on which he had challenged. Additionally, he further says that a report having not been accepted or the action taken report having not been submitted within the time of 6 months, does the report have any validity to be a basis for a disciplinary inquiry? You may have, Mr. Kohli, as regards those things which you have said about the SIT and all these things, may be a part of a separate disciplinary proceedings initiated on the basis thereof. It's another aspect. I'm not saying on that.
One of our, actually our response.
No, Mr. Kohli, let's not digress from anything. You may have all these things, which may be a part of a separate memorandum of charges issued under in terms with Section 9.2, Rule 9.2 of the Assam Discipline and Appeal Rules. That's another aspect of the matter. I'm not that. But the fact remains here, the only basis is the Justice B.K. Sharma's report. So if that cannot stand, it is a case which needs to be interfered with. But
What I was just pointing to Lordship's consideration, that in our response, we have specifically averred and annexed is the charge sheet, because we are also relying, that's what I'm trying to say, the material, Lordship may just make one note of one thing, the material that was placed before the one-man commission was essentially the material of the police investigation.
no, then are you saying that the show cause notice or the memorandum of charge, where you have mentioned only the document encloses the extract of Justice B.K. Sharma's report, you are going to further complement it with further documents?
Because
You
also
cannot.
show cause notice mentions the word.
No, Mr. Kohli, no. Mr. Kohli, kindly read 9.2. You cannot do that.
Lordship may just come also to the show cause.
No, show cause I will read it. No. 9.2, let us read 9.2. Because that would again cause a
Yes.
prejudice.
It's a different parameter, Mallat.
Kindly look into this. Kindly come to 9.2. the disciplinary authority shall frame definite charges, which is there at page 48, on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with the statement of allegation on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by so and so a written statement of his defense and as to whether he would desires to be heard in person. At the time of delivering, the defense shall invariably furnish to the heir a list of documents and witness by which each article of charge is to be proved to be sustained. So therefore, what document you have here is the report of, more particularly not even the report, the extract. Now, Mr. Kohli, you must have looked into the report of the Justice B.K. Sharma's commission, and also I think the proceedings of Justice B.K. Sharma's commission. Is it anywhere mentioned that after he had submitted the reply, any further action was taken by Justice B.K. Sharma on that? He may not know.
No, Milord, no.
He may say so, but
has
he
not
may
rebutted.
not know.
He has
But
not rebutted, Milord.
you are the
Ultimately, Milord.
person who has the access to the records of the Justice B.K. Sharma's commission.
Public domain now.
No. The report is in the public domain. But whether the proceedings inside by which every order was passed out there, is it mentioned that yes, we have received this and we have thought that his evidence is not required, he may not be given the right of cross-examination. These are many things which may happen. Otherwise, finished.
We have also put it in our reply, Lordship.
So the only thing, Mr. Kohli, now we have to, matter is heard.
Rule 6 was
No more.
Lordship.
We heard everything. Now the only question is whether any action taken report have been submitted within the period of 6 months. That's all.
And my lord,
Lordship, just for a
let my
moment.
learned friend, my lord,
May I?
place the report and the records of the commission before your lordship, because there are directions, my lord, 3 directions from the court. 3 directions. Please have the order of 6 December, my lord. Direction, produce the one-man commission report, courts. Followed by in 7 January, Justice Shyam directs that you produce the one-man commission tomorrow report. Till date, my lord, the report is.
Mr. Chaudhary, you must be an affluent advocate. But the fact remains out here, the state government cannot, it's this big, to
Okay,
keep
I
on
will
making
give it
photocopy.
my lord. The date from my pocket.
But it's filed
Let
in
them
one
bring
of-
it here, my lord.
Lordship, it is on instruction. It is filed in one of the matters. It's in public domain, Lordship. Lordship may come to 205.
No, have you filed?
Not in this batch.
You haven't filed it. The
Lordship may
direction.
come to 205 for a minute.
Where?
Or Lordship may just open the disciplinary rules of 64, Rule 6 suspension.
Suspension is another. Mr. Kohli, suspension is another aspect. Suspension is a thing like this. You may keep on him under suspension, taking into account the gravity of the offense out there. You may keep him under suspension, but you need to have a periodical review, which is being held in Ajay Chaudhary's case and subsequently
Judicial
repeated
judgment.
in many
Yes.
judgments.
My lords have also passed quite a few judgments, my lord.
So these are things which can be very well. You may see the judgment. There is one judgment, I forgot the name.
Yes, because I pulled out all your lordship's judgments.
He was also a DIG and also that he was the Mr. Chaudhary, Kane Chaudhary, that matter which was there, I did not interfere with the suspension. That one.
Yes.
There I have laid down certain parameters, how you continue when there is a proceedings going on.
Yes, my lord.
You
that's,
have to take a conscious decision that
that's
whether it is
in
necessary.
2024 5 JLR 43.
So that is what, this has to be looked into in those parameters out there.
That's the second limb of my challenge.
What?
There's no periodic review. And in fact, my lord, the last periodic review which happened is on 5th April 2024.
In fact, my lord, I may say one thing. Ajay Chaudhary came in 2015,
Yes,
whereas Assam government circulars of 71 speaks of the same thing,
periodic review.
contained in the manual of departmental instruction.
Yes.
71. Chief Secretary going to the
Yes, that Prasanto Datta.
Yes.
No, anyway, they
No,
can
that's-
still, we can give them an opportunity of reviewing. That is what can be done. There's no worry.
Yes.
Within the 15 days, they'll let them review it, whether to continue or not, keeping into account those parameters and all.
No,
Okay,
Malad,
over, I
no,
think.
Malad, once that 90 days period lapses, the suspension order goes. That's the
No,
law.
no. Here you have been issued the, you see, you have already been issued a show cause notice,
Yes.
the memorandum of charge. Memorandum of charge has been issued.
Yes.
So once the memorandum of charge is issued, paragraph number 22 of Ajay Chaudhary says
About-
that 90 days, but paragraph number 21 says about 90 days. But if you see paragraph number 22, it says that in the meantime, as the charge sheet has already been submitted, we need not go into that.
That is in the context of that facts.
Yes, that is why here, as of now,
charge sheet is not
the
submitted.
charge sheet has already been given to them.
No,
This is the memorandum of charge.
just the show cause notice. That's all.
No, that is the memorandum of charge made under 9.2.
Yeah.
This is the
If you
memorandum of
kindly have a
charge.
Look at para 3 of Ajay Chaudhary, then Lordship will get the meaning of para 22.
No, I have got it. You see, in Ajay Chaudhary, the Supreme Court did not interfere with the suspension.
Because of para 3, please read para 3
Para
of the
three.
facts. If your Lordship would kindly see, my Lord, para 2 and 3,
Yes.
various litigations was fruitlessly initiated by the appellant, para 2, my Lord, in the Central Administrative Tribunal Chandigarh bench, as well as in Punjab and Haryana High Court, with which we are not concerned. The appellant asserts that since the subject land was within the parameter wall of Air Force Station, no physical transfer thereof has occurred. On 28/12/11, the appellant suspension was extended for the first time for a further period of 180 days. This prompted the appellant to approach the Central Administrative Tribunal, and during pendency of the proceeding, the second extension was ordered with effect from 26/6/12 for another period of 180 days. The challenge to this extension did not meet with success before CAT. Therefore, third extension of the appellant suspension was ordered on 21/12/12, but for a period of 90 days. It came to be followed by the fourth suspension for yet another period of 90 days with effect from 22/3/2013. Now, this is important. It appears the tribunal gave partial relief to the appellant in terms of the order dated 22/5/13, opining that no employee can indefinitely be suspended, that disciplinary proceedings have to be concluded within a reasonable period. CAT directed that if no charge memo was issued to the appellant before expiry of 21/6/13 of the then prevailing period, the appellant would be reinstated in service. CAT further ordered that if it was decided to conduct an inquiry, it had to be concluded in a time-bound manner. The appellant alleges the suspension was not extended beyond 19/6/2013, but this is not correct. Respondent Union have filed a writ petition before the Delhi High Court contending that tribunal had exercised power not possessed by it inasmuch as it directed that suspension would not be extended if charge memo was served on the appellant after expiry of 90 days from 19/3/13. This challenge has found favor with the court in terms of the impugned judgment dated so and so. The writ court formulated the question before it to be so and so, whether impugned direction circumscribing the government's power to continue suspension and also to issue search sheet within the time-bound manner can be sustained. Ajay Kumar Chaudhary. Then my lord will kindly come to paragraph 5. This led to the filing of the appeal before this court. In the hearing held on 11/7/14, it was noted that by letter dated 13/6/14, the suspension of the appellant had been continued for a further period of 90 days with effect from 15/6/14.
Mr. K.N. Chaudhary,
My lord.
kindly read paragraph 22.
Yes, my lord, paragraph 22 has to be understood in the facts of this case.
I have understood the facts of the case.
Yes.
I may in verbatim tell you the facts of the case.
No, so far as the
Kindly
facts of...
read paragraph 22.
Yes, I've said I did, my lord.
Yeah.
So far as the facts of the present case are concerned, the appellant has now been served with a search sheet, and therefore this direction may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continuity in any other manner known to.
So on the basis of merits, then he can very well challenge it. Not on the basis of violation of Article 21. I have given around 40 judgments on this.
I have pulled out all.
So nothing.
I'll just...
We need some time to get that, Lordship. He was trying to contact the officer, he couldn't speak. Because Lordship
That one I
indicated otherwise specifically, and we'll respond on that specifically. Your Lordship's question, if I've gathered, is specific to the action taken report being part of it, and therefore Lordship is saying that if that is not there, we cannot take any action per se based on the rules and the act itself. And therefore, since the challenge is also to the Commission of Inquiry, and therefore broadly the foundation being therefore questionable.
You may, as I said, Mr. Kohli, you may very well drop a fresh charge. There's no res judicata. Without prejudice, I may quash it. Without prejudice, because there's no res judicata out here, or for the purpose that there is a double jeopardy out here. The question doesn't arise, taking into account that. But it doesn't stop you on the basis of the SIT inquiry or criminal investigation. You may very well do it. There's no quarrel with that. But in the meantime, the thing is, as on date, on the basis of this, because what is happening, Mr. Kohli, you also have to understand, what is happening is, in view of this, show cause notice has been framed up in this manner. At the end of the day, you may not succeed. You have to understand, take a more pragmatic and a prudent point of view.
If I
Yeah.
am an officer of the court, I
Yeah.
know where the court is coming. That's why I said
So
he
therefore,
said I-
this show cause notice, which is under 9.2, may not succeed. You may have a lot of problems. Every hurdle you have. But if you want to make a case on the basis of the other aspect, very well, you have a case. So that is the only thing.
No, I'm of course, we of course, Lordship are finally in your hands.
Now, my lord, on the other aspect also, my lords,
Which one?
which my friend is saying, my lords, that the police investigation is pending. I will show from the record, my lords, on 30th November 2023, when the writ petitioners were suspended from service, there was no criminal case pending against the writ.
No, but now it's pending.
Yes, but point, my lords, is
Because of that, they may review it.
yes.
No, they may now also review it.
Yes.
They have the power to review.
Existence of power is one thing, but
They may look into various aspects. Now, but the question is whether it is right or wrong, whether it is reasonable or not. That will be the subject matter of consideration, which may be looked into in an appropriate case.
Yes.
That is why, if you see in Ajay Chaudhary paragraph number 22 says that, okay, we are not interfering on the basis that the charge sheet has already, but he still has the liberty in the circumstance it is not being done in this. Now, whether it is reasonable, whether it is conformity with Article 14 or not, that has can be looked into.
Yes.
Many a case, like a particular person concerned, he's just being suspended. The fact remains that that suspension, he is suspended, and in respect to a sanctioned post, that post cannot be filled up by anybody else.
Yes.
And would it be then in the exigency of the state to keep a person, the post vacant? These are many other things which looked into it. In fact, one of the orders which really was a beautiful order of the Bombay High Court was of Justice Ujjal Bhuiya, which I got to read it on a suspension matter, that whether it is in exigency of the state to keep a person in suspension, taking into account that this post under no circumstances can be filled up till these proceedings are not over. Now, this person is already getting initially 50%, then 75%. So the state is paying from its own coffers to maintain this particular person, but on the other hand, but the state is not getting anything. Would it be prominent? Or would it be necessary that you post him in some other place, somewhere, or somewhere you put him out there and thereby pay him? Or is it necessary, therefore, for the state to, if you are basing it on the basis of a criminal law, to have it on a special court and finish it off? These are things which the state may have to look into it. Getting complete?
one aspect.
What else?
I'm of course seeking Lordship's time to respond on that specifically.
Sure, then we stall it today.
No, no,
and
let's-
fin-
one aspect.
What
We
else?
need to- First is, one is my learned friend is going to come back to your lordships on whether the action taken report was submitted along with the report and laid before the house. That's one aspect. The second aspect is, my lords, there are 3 directions of the court to produce the one-man commission report and the records. That has still yet not been done.
If they don't produce it, the presumption will rise. Then,
Now the third aspect, my lords, which is even more important, is please have the order of 6 December 2020.
what is that?
That's an order, my lords, which state the suspension order, which the lordship saw at page 43. And 10th January 2025 is the order of Justice Uni Krishnan Nair, my lords, where the state came and said that you have only stayed the suspension, so we are not in a position to allow them to join. So my lords, on 10th January 2025, this court passes a positive order directing the reinstatement of the petitioners before your lordships, with a condition that consequential orders as would now be called for in pursuance to the directions passed by this court by the order dated 6/12/24 shall be issued by the respondent within a period of 1 week from today. My lord,
You have filed contempt?
yes, and one other
Where are the contempts?
contempts are not listed.
Well,
today.
then
No, no,
I'm
no,
not-
1 second.
not my duty.
Now, please have my lord IA 15604. 1564, my lords.
Mr. Chaudhary, I am going to listen and finish it off, this matter.
Yes, yes.
I am not
I'm
going to
grateful, my
go
lords.
into those
It's-
contempt, whether these orders have been complied or not.
One thing to say, my lords, this
You
order.
see, first and foremost, the question of, with due respect to the learned coordinate bench, the question of suspension of a suspension order doesn't go. It's two minus, two negatives doesn't make it
It
positive.
goes, my lords, if the
It doesn't
facts
go.
are so glaring.
That this amounts to giving the final relief.
Yeah, it's giving a final relief.
Now, my
A
lords,
suspension is an interim thing, so and that is being suspended.
now, my lords, whatever it is.
You may strike out the suspension order, say that, okay, partly I'm giving this relief of suspension is squashed. Then obviously things will follow.
If the facts are glaring, my lord, your lordship's hands are not tied sitting as a 226 court. Now, my lords, what has happened is this. 10th January, there is a direction. Within 7 days, you reinstate. They challenged these two orders before the division bench. Division bench dismissed the appeal on 19th February 2025, holding, my lords, in one paragraph that there is no illegality, there is no irregularity in the discretion exercised by the learned single judge in passing the orders. Right, my lord? Division bench also went to the extent of saying, since my learned friend argued on 8B compliance and all, that merely showing notices here and there does not show compliance of 8B. That division bench order. So division bench, my lords, has upheld this in interim orders of 6/12 and 10/1/2025. We are today, my lords, in 2026. Orders have not been complied with. Now, please have my IA 1564. Please have it, my lord, something to say.
What is there?
Just have one.
Lordship, I have a preliminary objection to that because he's raising a point on the chief minister's speech in the
Hang on.
assembly, ignoring the protection of Article 193(4)(2) of the Constitution of India, upheld by constitutional benches, and seeking purging of a contempt in which no contempt has been held. So, Lordship, I have a preliminary objection to that
Yes, okay, you make your point. But let me
preliminary objection would
let
have
me
to be
make
heard,
my point.
Lordship. Would have to be
Well,
heard at the outset. at
well,
the bench.
Who has filed this IA?
My lord, the petitioners here.
What is this?
This
Please see the prejudice.
1654, my lord.
What do you want?
1564.
To comply with the interim orders dated so and so, and to immediately purge themselves of the contempt before being heard, to failure to comply, withhold the further participation of the respondents in.
Now, my lords,
And this may be read with the prejudice.
Okay, enough. We passed the order now. When are you going to give us this particular report? It is you, we can have it tomorrow also. You said today and tomorrow you were there.
I think I'm aware that many of them may be busy, Lordship.
You only said that today and tomorrow the matter.
Yes, it was for today and tomorrow, but Lordship.
You were there, so you get the instruction.
On a lighter note, so
Yeah.
Lordship have to respond appropriately with better batting.
Anyway, so we have it when, because this thing, I'm drawing up an order now itself. I'll draw up an order and only ask you only these 2 points.
next week,
And thereupon we'll fix it on a particular date and finish it off.
next Thursday, my lord, if it suits your lordship.
Oh, we finish it off. The suspension order, you see, there are orders passed. Mr. Kohli, I think you should advise your clients properly, taking into account there are orders being passed by this court. It's a different thing. They have not filed the contempt or have filed the contempt.
filed
It
the
is not there. But it doesn't look show in good color that when the court has passed an order, although I'll take care of it and pass the final order and dispose it all, but it doesn't show in good light.
Application, Lordship.
It's
I
difficult,
think
my
you
lord,
should
for us. my lord.
convey it to your
Hmm.
clients, taking into account that they need to take up a, yes, you may take a different decision,
Take out the division bench order.
take up a issue. What you need to do is take up this issue properly, not in this manner. And you are trying to fight an issue which is very difficult for you.
Two parts. The first part, Lordship, I have heard what Lordship has said. We will come out with instructions. On the second, Lordship, I do wish to say respect.
Now, as of now, there are criminal proceedings pending.
It is.
So therefore, when the criminal proceedings are pending, you can very well, there is a provision out there by which you can very well take into account and suspend him, keep him under suspension, not give him a particular thing and all this thing. can very well look into
I,
it.
of course, have
Now,
looked at that at
therefore,
the
you
stage.
take up in a proper manner where the law permits, not in this manner.
But Lordship, on the second part, which is on the reinstatement, our application specifically quotes the settled law. That in a reinstatement being sought on a suspension of a suspension order, there will be no, that would not stand by itself because that would amount to giving the final release. So these are two separate things, Lordship. That's why I'm not arguing it because Lordship said, you'll see, that's a very small part of our, and the judgments are, we quoted it within the, what you call vacation of stay. On the contempt also, Lordship, there is settled law, we have, that judgments are there, that if we take our proper legal recourse of filing an appeal and or a review, or an IA seeking vacation of the order of which the contempt is held, then no contempt will lie. So we've also looked at that. But these are the legs of the main matter. This is the legs
No,
that we
no,
make.
Mr. Kohli, let us not go into those aspects of
Which
the
is what I
matter.
said,
You see, I make it very clear. From the materials on record, as I have heard and looked into it, I am going to set aside this so-called notice. I'm telling you, giving you liberty to initiate a fresh proceedings. As regards the suspension, and there are orders by which you cannot continue, but it shall be also at liberty to take an action, taking into account the criminal proceeding by following the law, and also as to whether it is necessary for you to do so. This should be done, this review should be conducted within a period of 15 days from the date of the judgment. This is what you are going to get. This judgment, I am just prolonging it, taking into account that you want to hold the instruction. Mr. Kohli, I don't want to, whatever report which has been given by justification, I think we should finish it at 4-3-4, and don't go into those other niceties because it may have a lot of embargo on this. So 3-4, we say that it has no value out there. It seems so because of the time which has been put at 3 months, 6 months. You have not done any action.
That is under law, not Lordship. I must say it is, I am also,
Yes, yes.
bound to assist
Yes.
Lordship. That 6 month is not sacrosanct. The 6 month period is not sacrosanct. It is extendable. There have been commissions of reports, Lordship knows in the Bombay was last after decades or so. So that issue is not there. The question that is germane from Lordship, which is what I have to get specific, is the action taken.
Because you see, the report only doesn't have any value. It has to have the action taken.
That I'm prima facie giving the mind of the court, that I would set aside, you would follow anything under law. It is basically premised on this fulcrum, is that the report, is it accompanied with an action taken report or not? Because in the absence of an action taken report, which is what has flowed from the bench, that there cannot be any action on a report that does not have an action taken report. That is the crux of what Lordship has
Yes.
said. The others, Lordship, of course, I would just place for your consideration, the 6 month period or the HBHC, we can argue because we have a point of view. The vacation, we can argue. The content, we can argue. But this fulcrum needs to be clear. And therefore, Lordship, I just seek that much indulgence to take a specific instruction on it. Additionally, have that interaction on the not just the in either side, looking at the overall picture, because I bow down to the court looking at the bigger picture beyond it. So
You have to
therefore,
look into that bigger picture because you cannot come up with something which is on a way. Anyway, now let me pass the order. We'll have it on next.
and Lordship has been most kind, which I must bow down to, which is that yes, that looking at the larger thing, I'm not restricting you from the liberty to proceed under due process of law, following the other route as
Because you have many
Nothing
other
stops them.
things to do this.
So Lordship, I would just say, Lordship, would it be okay if it can come perhaps Lordship in 2 weeks from now? It would give us sufficient time. Lordship would bear that, that everybody's put in
Okay.
their extremes with Lordship now that the process is starting around the corner. I don't want to come back without a full.
12th of February?
Uh,
12th of February, 2 weeks.
Can be the following week, if I can pray.
Then I may take you all to Kohima.
Nagaland. I have been there a long time. It would be likely to appear before you. But Lordship, I don't know if this matter could get transferred. My learned friend may not have.
No,
a
Mr.
different view.
Kohli, the problem which you have in producing the copy and giving a copy of the entire report, High Court also has a little financial constraint to carry all these files from here.
I not ask the state or the High Court to be burdened.
11th lordship.
11th is not possible, 12th.
I have a matter in actually Manipur, so that is why I was.
Manipur has good virtual, you can do the matter
No,
virtual.
then the judge has specifically, lordship has said that Nalin, I want you physically involved.
And good.
Otherwise, I was doing it virtually, much more convenient.
Okay, on this aspect, we'll look into it. At 2. At 2 on 11th.
Absolutely, I am.
Heard Mr. A. Chaudhary, the learned counsel, senior counsel assisted by Mr. B. Chaudhary, appearing on behalf of the petitioner. And the other petitioner. I've also heard Mr. N. Kohli, you are the additional advocate general?
No longer, he's senior advocate, he's appearing as a senior.
Okay. Mr. N. Kohli, the learned senior counsel, assisted by so-and-so who represents the respondent state. The present batch of writ petitions have been filed challenging the one-man committee report submitted by Honorable Justice B.K. Sharma,
Specifically, rule 8
bracket retired,
and rule 8B. Sorry.
as well as also the initiation of departmental proceedings on the basis of the said report. Mr. A. Chaudhary, the learned senior counsel, submits that a one-man committee report which have been submitted is a report made in terms with the Commission of Inquiries Act 1952. He submits that after issuance of notice to the petitioner on 13/8/2021 in WPC number 5862/2024, and likewise in respect to other petitioners in the batch of writ petitions. The petitioners have submitted a written statement denying to the contents of the allegations made in the said notices. Thereupon, nothing was informed to the petitioners. The learned counsel, senior counsel further submits that the manner in which the learned, the one-man committee had progressed defies the provisions of Section 8 capital B and 8 capital C of the Commission of Inquiry Act 1952, and thereby insurmountable prejudice has been caused to the petitioners. He further submits that the law, it is no longer res intriga that if there is a violation to the provisions of Section 8 capital B and 8 capital C of the Act of 1952, the said Commission of Inquiry report cannot withstand the scrutiny of law.
Not involved.
The learned senior counsel further submits that on the date on which the commission, the one-man committee report was submitted, before the before the state government on
12th October 2023.
12th of October 2023.
When was the date before that?
Full stop. He submitted that to his information, the said report have been tabled in the Legislative Assembly
On 17th February 2025.
on 17th of February 2025. But however, the same have not been done so with the action taken report, which is the mandate of law in terms with Section 3(4) of the Act of 1952. The learned senior counsel therefore submits that the mandate of Section 3(4) of the Act of 1952 further mandates that the state report along with the action taken report is required to be submitted within a period of 6 months from the date this report is being submitted. And in the instant case, it has been submitted almost around 2 years. That too without the action taken report. The senior counsel therefore submits that the disciplinary the learned senior counsel therefore submits that if the report of the one-man committee is the only basis on which the entire disciplinary action stands, proceedings have been initiated. It cannot, which the said show cause the said memorandum of charges cannot withstand, cannot be permitted to continue as it would amount to abuse of the process of the court. The learned senior counsel for the petitioner further submitted that the petitioners have been suspended sometime in the year 2023,
November 2023.
November 2023.
30th November, that's all.
And the petitioners continue to remain on the suspension that there has been no review which is required.
Yeah. After the stay, they have stopped the review insofar these petitioners are concerned.
The review. Earlier there was review.
Earlier there was, but not within that 90 days period, my lord.
There was review earlier after
okay.
stay lordship because.
There was submitted that the suspension was suspended. All the petitioners have been suspended sometime in the on 30th of November 2023. Initially, there were periodical reviews, but pursuant to the order passed by this court, whereby the suspension order has been stayed, there has been no further reviews. And as such, it not only violates the mandate of the judgment of the Supreme Court in the case of Ajay Kumar Chaudhary versus Union of India, reported in 2015, 7 SCC 291, but also violates the very circular of the state government, dated
Circular of the state government.
where is that Prasanto? What is that? Please?
Yes. Prahanta Datta.
You see, there is a number attached. It's 3/4/2021. Wait, no? I'll give. Wait. Office memorandum dated 4/2/2020, issued by the Chief Secretary, Government of Assam. By contra, Mr. N. Kohli, the learned senior counsel appearing on behalf of the state of Assam, submitted that he would obtain instructions as to whether the action taken report was submitted along with whether the report of the one-man committee was placed before the Legislative Assembly along with the action taken report. The learned senior counsel further submitted that it is it is not sacrosanct that the mandate of the 6 months period. The learned senior counsel further submits that the 6 months period as mandated in section 3(4) of the Act of 1952 is not mandatory, as has been held by various judgments of the Supreme Court.
No Supreme Court, the High Court. There's a cleavage of opinion between various high courts.
High Court?
Yes. High Court.
By certain high courts.
But there's a cleavage.
And as such, the laying of the report beyond the period of 6 months would not nullify the effect of the report. Be that as it may, he submitted that he would ask his assisting counsel to obtain instructions from the state of Assam as to whether the action taken report had been submitted, was tabled along with the report before the Legislative Assembly.
Why?
HB8C, which is my argument, which is part of this, that in any case, on the argument of 8B and 8C, it is the state stand that the compliance of 8B and 8C has happened in terms of the notice that was sent.
Let me go. I'm only on 3-4 now. Let me come to remaining one.
apologize. I didn't
No,
realize.
fair,
I
yeah.
forgot.
Countering the arguments made by the senior counsel for the petitioner as regards the infraction to section 8B and 8C of the Act of 1952. The learned senior counsel submitted that the mandate of section 8B and 8C were duly complied with by the one-man committee. And as such, there is no violation of the said two provisions. In addition to that, the learned counsel therefore submitted. In addition to that, it is also the submission of the learned senior counsel that taking into account that the memorandum of charges were only issued, it may not be proper of this court at this stage to interfere with the said discipline proceedings. The learned senior counsel further submitted that in respect to the suspension, he would obtain instructions in that regard.
The ATR,
Huh?
action taken report.
No, suspension.
I see.
Let us not put it that you contest. He'll obtain instructions in that regard. So, this court have heard the learned counsel's have heard the learned counsels on the various issues. And for the purpose of an effective adjudication, the instruction as to whether the action taken report was tabled along with the report of the one-man committee before the Legislative Assembly is an aspect which needs to be ascertained. This court also duly takes note of that on one hand, the learned senior counsel appearing on behalf of the petitioner have submitted that there is an infraction to section 8 capital B and 8 capital C of the Act of 1952 by the commissioner of the one-man of the
One-man
by the-
commission of
by the-
inquiry.
one-man-
One-man commission of inquiry.
one-man commission of inquiry, which the senior counsel for the respondent submits, senior counsel for the respondent state refutes. It is the opinion of this court that such refuting has to be based on records. The records pertaining to the one-man committee, which would show that the petitioners were duly informed pursuant to the submission of the statements, or what steps the one-man committee, report took pursuant to the submission of the statements by the petitioners, have to be placed before this court. In absence of such materials, a presumption has to be drawn that such steps were not taken by the one-man committee. Liberty given to the respondent state to produce the report of the one-man committee, as well as those orders, which would show that certain steps were taken by the one-man committee in that regard. Failure to do so, the law would take its course. List this matter again on 11th of February 2026 at 2 p.m.
Interim orders to continue.
What interim orders?
Please see the last order.
The suspension is stayed, Lordship.
Please.
Suspension stay there. Mr.
Something to
Chaudhary,
say here.
Mr. Chaudhary, don't make me a party to this suspension stay.
Orders are continuing on the.
I've never heard of suspensions being stayed.
There are orders continuing since 2024 December.
Tell the division bench tomorrow that this judge forgot to extend the interim order.
Since your lordship is today.
I've heard the matter. Yeah, matter on 11th we'll finish it off.
No, but let the position continue, let the position continue today.
Whatever order is there, this is there.
Lordship, there was just one submission when I had referred to the PR Naik judgment. And once the commission had issued the notice to them, it was incumbent on them to respond. Because, and that is what it says.
No, Mr. Kohli. You have to appreciate one thing. When he submits a report, when he submits the statement, listen. When the petitioner has submitted the statement, what action the Commission of Inquiry have taken is a thing which has to be noted.
Yes,
I'm not saying that whether he has been informed. No. I'm asking what Commission of Inquiry must have applied. Once you issue a notice on 13/8, it is also incumbent upon the Commission of Inquiry report to look into it or just not to keep it as a waste paper.
One is what Lordship has said in the action taken report. One is what Lordship has just spoken. I'm just taking the second leg of the HB and HC. So I'm not, Lordship, these are two separate aspects. I'm merely saying that in terms of HB and HC, when one sends out the notice and they respond or they don't respond, that is incumbent upon them, which is the PR Naik judgment. So I was only pointing at. So they need to take steps. That was the point.
My friend has turned the law upside down, my lords. I will place the law that it is
it's
incumbent on the commission, my lords, to ensure that the safeguards under 8B and 8C. No, he has to call the parties and allow him to appear before the commission.
I have not dictated the final judgment,
Yes.
which I'll leave it on.
I will place the law the next day, my lord.
Whole batch is coming up on 11th.
And what about the disciplinary proceedings I'm coming in?
That will go along with this only.
No, we'll finish it up. That is a
My lord, I appear in item number 58, 59, 68, 70, 71, 72 and 74. My lord, here we have not specifically pleaded the point which my colleague Mr. Chaudhary has argued, my lord. But then my lord, the language of the show cause notice is same. So in that view of the matter, my lord, since your lordship is taking up the matter on 11, may I pray your lordship's leave? If necessary, I'll file an affidavit to that extent, my lord. I may be allowed to urge that point also. Otherwise, our writ petition is basically structured on the basis that on the same set of facts, my lord, the writ petition, the disciplinary proceeding and the criminal case are grounded. So therefore, until conclusion of the criminal case, my lord, a disciplinary proceeding normally should not proceed. It was in that perspective, my lord, limited interim order was granted.
What is the interim order?
My lord, that DP has been
Mr.
stayed.
Kohli, there was an interim order in the earlier case, not on the suspension. But
In our case, my lord, suspension is not involved.
Earlier case, there was an interim order to the effect that the disciplinary proceedings should not progress. So that interim order shall proceed.
Yes,
In this case. Where is
Chaudhary's
it?
case.
Mr. H. Chaudhary is not there. He must have left. Delhi councils. Earlier, he Kestuthal, interim orders passed earlier shall continue till the next date.
Just one thing only, Lordship, respectfully, rather late in the day to move an affidavit to say that we'd like to urge a fresh ground. But
There's
we are on
nothing
the
like
final
it.
hearing.
Even
But
before
yeah.
delivery of judgment, also amendments can be allowed.
I'm aware of. I'm just simply pointing out, Lordship, because on this one, there is clearly, of course, the law is very settled. Mr. Chaudhary would like to argue the exception, and we would argue that the exception is not applicable in terms of parallel proceedings. So therefore, Lordship, if I may respectfully say, that is something we would definitely then not point out. If it is to be considered that they will be amending it, like
No, amending is too late
Not
in the
am-
day.
my lord.
It's been
It's
fixed.
a question of law, otherwise, lot pleadings are there, but not specifically regarding A, B, C. Otherwise, pleadings are there, but not very, to be honest, my lord.
Then Lordship, if they are saying so, I would respectfully urge Lordship to consider our opposition to that, Lordship, because.
Oh, definitely.
End of the day, my lord, all the charge sheets are drafted in the same way, my lord. There also, in our charge sheet also, they say that B.K. Sharma, Commission of Inquiry has cyclostyle.
But they have something more, yeah?
No, my lord.
Let us see the
Exactly same.
contents of the charge sheet.
Same, my lord.
They have based on commission inquiry, Lordship. This is on parallel proceedings.
No, here they are giving the FSL report and all Caesar notice, Caesar list, everything is
Lordship,
written.
In our case, the show cause
Kindly come
notice,
to, kindly come to page 34.
page 57, my lord.
Page 34.
Lordship.
Page 34. I am taking up item number, I don't know, from Saijan Sarkar or something, 3698.
Shahjahan Sarkar.
Shahjahan Sarkar.
Yes,
Yes, my lord, item number 58. 58.
this one. So there,
There, my lord, the show cause notice is at page
no, the
57.
showcase notice is okay. It is similarly worded.
Ah.
But the fact remains that page 34 of the charge sheet, they have relied upon various other documents, which is not a part of the charge sheet.
Page 34, my lord. No, regarding Shahjahan Sarkar, my lord, at page 47 to 49.
I'll see you.
This one.
So this is separate. These are allegations which are not there in the disciplinary proceeding reports.
No, my lord, because the case is premised on the point that on the same set of charges, the disciplinary, no, kindly see the charges in the disciplinary, a statement of allegation in the disciplinary proceeding. Yes. And before that, Lordship has seen there is page 47, the statement of allegation is at 59.
Yes.
Kindly see, my lord, 59. It has been reported by one-man commission of Justice retired B.K. Sharma about anomalies and malpractice resorted to for selection of candidate with money and other extraneous consideration by Assam Pass. Same thing.
But the allegations.
And
at
kindly
page-
see this page 60, my lord.
No, the allegations at page 48 to 47 to 49 as regards Shahjahan Sarkar do not mention anything as regards the BK Sharma's report.
No, if my case is premised solely on the basis that on the criminal charge and the DP are on the same set of facts, there I may not succeed. But for the purpose of other one, my lord, it is the same. my lord.
So therefore, the moment this type of repetition, if you are filing a, you are having a, you are putting, you are saying you are putting yourself in more muddy waters. The reason is you are saying that the criminal proceedings and the disciplinary proceedings are on the same charge. But
Set of facts.
same set of facts, meaning thereby you are qualifying the charges which are made in the charge sheet is a part of the BK Sharma's report. Would it be advisable for you to do that?
No, I agree, my lord. That there your lordship is correct. But if your lordship looks at page number 47, my lord, what do they say? End of the day, my lord, these are the findings of the BK Sharma committee report.
Maybe. But BK Sharma's report has been assailed out here on the basis that it has no legal legs to stand. But what they have done now here in this would have been proper if, as I was suggesting, Mr. Kohli out there, that okay, give up these type of show cause notice and proceed with as per the charge sheet. They can very well go ahead in this and have it. But now what you are saying that the BK Sharma's report is based upon these, or these charges are based upon BK Sharma's report, meaning thereby you are giving credence to the BK Sharma's report. Would it be advisable to do that?
Follow. No, my lord, it is a point which we could not perceive, my lord. For our fault, my lord, why should our client suffer? Let me put it very bluntly. But that's why I'm saying, my lord, we should be allowed to ask this point, my lord. we'll file an affidavit seeking your lordship's leave. In any case, lordship is taking up the matter on 11. By the time I'll get the pleadings ready.
Better off withdraw these petitions and come up with a fresh one. I realize why I'm saying so. Here, if you bring in the BK Sharma's report, here, with these set of facts which are already there, meaning thereby you are giving credibility to the BK Sharma's report on the basis of the charge sheet, you are in trouble. You get a point? He has not, Mr. Chaudhary's case is not done that. He only sticks to BK Sharma's credibility.
That I agree, but all that I'm trying to distinguish is, my lord,
On both
because my case was premised on a different point altogether.
Now, understood.
Yes.
You want to go on that there should not be on the basis of that
Yes.
judgment of the Supreme Court itself. But the law had changed in the meantime.
Just to add,
No,
Lordship,
my lord, GM Tang, Paul Anthony, these are still holding the field, my lord.
We'll
Right,
look
right,
into
Lordship,
that.
Mr.
If you want to stick on that issue, you can very well do
No,
it.
no, I'm not
At the-
trying
at
to
the-
do
at
that,
your
but-
risk, you do it.
All that
But
I'm
the
saying is,
problem
my
which
lord,
you may face is this.
my lord, I may not press this point, my lord. Lordship will kindly permit me to come up with an additional pleadings, my lord, to ask this one.
Mr. Chaudhary, I have no problem in permitting you.
Yes.
But the problem which is there is with that and contradictory pleadings that both are on the same footing. You see, his thing is what he is saying. But look here, BK Sharma's report is based on a violation of section 8B and 8C. And as such, you cannot rely on BK Sharma's report. It has to go in qua the petitioner. Second, the BK Sharma's report is a report which has though been tabled at a later stage after 2 years, but it is not there with an action taken report, and as such it has no value. So that cannot be the basis of a disciplinary proceeding which has no edifice. That is what.
In other words, my lord, the premise itself is
Wrong.
not legitimate.
Not legitimate. Now, on the other hand, what you are saying out here, you want to take that point also? And on the other hand, you're saying the BK Sharma's report as well as the charge sheet are one and the same. Meaning thereby, I am not giving the credence to the BK Sharma's report. My question is there.
Followed, slightly tricky, my lord.
It becomes you are more
And
sticking
my lord,
to
I'll
the-
take a call on this, my lord. For today, my lord, my only prayer is let the matter be called on 11, my lord. The rest, in the meantime, my lord, we'll take a call on the issue.
But if you file that affidavit, you will
Yes.
be in more trouble.
No,
I just want one thing just to just assist Lordship is that in Mr. Chaudhary, as in Arnab Chaudhary's batch Lordship, they have challenged both, which is the one-man commission as also parallel. Mr. Kian Chaudhary's case is premised only on the parallel.
That is what I'm saying.
That's the thing,
No,
yeah.
therefore I'm saying what he wants to do, he wants, on one hand, he is saying the BK Sharma's report is there and the criminal proceedings are both together. That means giving the evidence which is there. You see, BK Sharma's report is no evidence. It is just a recommendation. It's not an evidence. What is evidence is what is there in the charge sheet, all these documents which will be the part of the evidence. So this is there. So now, by way of that, the BK Sharma's report is being substantiated by the charge sheet. And now if he challenges the BK Sharma's report that he doesn't have, how do you jail both?
Our stand was only as long as Mr. Chaudhary is not present
No,
for any change of his.
Well, I have followed it, my
I'm
lord.
okay.
I'll take
Otherwise,
the
I'm okay.
corrective measures. Lordship will kindly, for the
Yeah,
today, my lord, Lordship, I've taken note of what is followed.
So this I have not heard it.
Yes.
Why should I have it on 11th?
No, let the matter come on 11. It's just said,
Fair point, no? Fair point.
no, since your lordship is hearing them on 11.
Otherwise, on 11th, we will argue this, Lordship.
Huh?
Otherwise, on 11th, we'll end up arguing this separately, Lordship.
No, this is a separate set has
Separate
been
set,
made
Lordship.
out.
No, under different heading, these matters have come.
Mr. K. N. Chaudhary, the learned senior counsel, heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. D.J. Das, appearing on behalf of the petitioners in this present batch of writ petition, and also Mr. N. Kohli, the learned senior counsel, assisted by so-and-so, who represents the state of Assam. The present batch of writ petitions have assailed the continuation of the disciplinary proceedings while the criminal proceedings are going on against the petitioners are presently ongoing. Full. The very basis of the case of the petitioner is that the petitioners would be severely prejudiced if the present disciplinary proceedings are allowed to proceed pending disposal of the criminal proceedings. The question therefore arises in the present batch of writ petition is as to whether the disciplinary proceedings should be allowed to continue pending the disposal of the criminal proceedings. Mr. K. N. Chaudhary, the learned senior counsel, seeks for certain accommodation to file an additional affidavit. List this matter again on 11/2/2026 at 2 p.m.
Deeply. Vehemently objecting to it.
Yes, file. We don't know what is he filing.
Great. Different. The life should be. Getting this item for the is that clear?
Wait, Mr. Lordship. In this case, the petitioner's husband, he was working as a head assistant in DRDA. In the year 2000.
DRT.
DRDA.
Where?
In the year earlier also.
Head
Thereafter,
assistant in
DRDA Kasar Lodge. Hailakandi.
Then
Chip,
DRDA.
DRDA.
Ah.
On 29/7/2017, the DRDA was wind up and then his service was, he continued his service in the Zilla Parishad. It was marked with the Zilla Parishad. And when his service was marched to the Zilla Parishad, he was not given the.
Where is your list of dates?
The reclusion second page immediately after the synopsis.
No list of here. Okay, so here. Then judgment and order. What is this?
He approached this honorable court earlier
Why?
because he was not given the post of head assistant when he was, when the murder was taken place. He was given the post of UDA. Therefore, he filed this petition and this honorable court allowed. Lordship may see the page 34, that is the operative part of the judgment.
Zilla Parishad, including areas and other service benefits. So you want release all the pecuniary benefits of the post of head assistant.
Yes.
Did you get promotion into a head assistant?
He was directed to be given the post of head assistant and the other pecuniary benefits by this order.
Then
Then the respondent did not take any action. In the meantime, I filed a contempt petition. This is the second case. During pendency of the contempt petition, the petitioner died. And we filed substitution petition, we were substituted. And in the meantime, I filed this petition because since the order is to accommodate person as the head assistant, after his death, that cannot
where is
be.
your promotion? Proposal for creation of the post of head assistant in respect of Shyam Nandi.
Shamal Nandi.
Then you died in 2021.
Yes.
I, Suman AMR Khan, in view of that, it is hereby provided Purnima Nandi shall stand substituted in the original petition. Now, the original petition was filed by whom?
By Shamal Nandi.
By the son, by the wife.
No, by the husband.
By
The
the,
petitioner.
no, the original petition was filed by Srimati Purnima Nandi.
No, Lordship. Actually, what
No,
happened?
the second one, this
Yes,
one.
yes. Second one is filed by, after his death.
Okay, I am directed to convey the sanction of creation of a personal post of head assistant under the Panchayat and so of the Guwahati High Court. Order dated so. The expenditure sanction is given in so. So in 2021, you died.
Yes, sir.
2022, they create a post.
After my death, after
It's
having the
okay.
knowledge,
They create a post.
yes,
Then,
that would not be affected then with
Huh?
that order. Since the petitioner died, therefore he could not be given the, should not make the head assistant.
now where is the direction passed by this court?
It is at page 34, 33, 34.
According to state, directed to create a personal post of head assistant if needed to accommodate the petitioner as the head assistant in the panchayat and remand. It may be noted that the post of head assistant was very much in existence in the DRDA, which was earlier occupied by Sanjan but became vacant after he resigned from its post. As the absorption of the post of Srilavija had remained under cloud, which has been dispelled now, let us take appropriate steps for accommodating the petitioner as a head assistant in Hailakandi Parishad and release all pecuniary, including the areas and grant of benefit attached to the post of year, which shall be undertaken within a period of a year. Now, where is the question of areas?
Because he was working as head assistant even before merger. So when he was given the post of UDA, he prayed for giving the post of head assistant, and this court allowed and directed to give the salary from the date of merger.
Where?
Because that is the area I want to see.
You know, the valid that accept the objection of the state. Well, Now understood, but where does this court hold that you are entitled to the head assistant from the date of merger? Yes, Mr. Doctor.
One order was passed, my lord, to direct, to create one post, my lord, personnel post, and thereafter to promote, my lord. We have initiated. my lord,
But this personal post was to be done within a period of 4 months.
that explanation I have in the contempt case, I have explained everything, my lord,
Ah.
why that time was taken.
What?
Lordship, I kindly have the contempt.
No, why time was required?
My lord, because of some procedural lapse, my lord.
It's okay.
My lord.
So why he can't be given the benefit within 4 months?
My lord, it was under process, my lord. Initially, there was one decision, my lord, to file appeal, my lord. Thereafter, my lord, the opinion from judicial department was taken, my lord. And judicial department, my lord, point that, my lord, to go with comply with the order, my lord. Thereafter, my lord, some official, my lord,
No, did you file an appeal against this order?
no, my lord. Thereafter,
So
my lord,
then
tried to
for
comply.
you were directed to comply within a period of 4 months from the year 2018,
Yes.
15/11/2018. So thereby by 4th of March to the 15th of March 2018, 2019, he was to be given.
My lord, on the issue, my lord, now, my lord, whether that delay will create right to the petitioner husband.
Oh, yes, why not?
That is, if lordship holds that, my lord, that I will not say anything.
No,
But-
because you see, the direction was to comply within 4 months. You have to also understand that in the meantime, the petitioner, after fighting all this litigation, have lost, have won the case, and then because of the delay on your part, this has happened. You have taken the, but the court say, did you seek for an extension of the period?
That,
You did not extension. Okay, the contempt was there, then you have come up with this thing only in 2022.
Right.
And now against this supernumerary post, he cannot be done. Now, the question is, you have created a supernumerary post in the year 2022. This supernumerary post, the benefit has to be given with effect from 15/3/2019. Latest.
There is one thing, Lordship.
Post is there.
But post was created later on, but
Maybe.
before creating the post, he was expired.
Huh?
Before creating the post,
He expired, but the fact that it is because of your delay, because the court directed you to complete within 4 months.
that is their manner, but whether that will accrue the right of the petitioner. That is
The right has been already created and declared. It is not a creation of a right. The right was there and the right was declared.
My lord.
And that declared, and to give effect to that was given 4 months. So let us take the last of the date, that is 15/3/2019. is
4 months from the date of the order.
15/3/2019, the last date. So he may not be given the date on 15/11, but 15/3/2019 is the date on which he becomes the head. He had to be made. So from that date also, yes, there might have been a delay on your part to have these formalities being completed. But unless you seek an extension for a period, you're bound to comply with it. And therefore, if you don't give, he has to be given the notional benefit from the post which is being created has to be given notional benefit from that date. And it is only for that post will be only for not for any other period. That his benefit will not be there for more than this period till his death. It will be from 15/3/2019 to the day he has died in the year 2021. There only the areas will be there. But his pensionary will be the family pension thereupon, or his pension, whatever may be, shall be accounted on the basis of that scale.
On that line, Lord,
I think that is a fair thing.
only thing I want to say about the earlier petition was filed claiming the post of head assistant from the date of merger. And
But that was not given.
paragraph 40, page 33, what you may see,
Paragraph
40,
42.
page 33.
Yes.
For the reasons discussed above, the court is of the view that the objection raised by the state government is without any merit and also unreasonable, as they are to blame themselves for the situation which has been brought into existence. Hence, the state government cannot deny the promotion to the petitioner to the post of head assistant.
But
Actually,
where is it mentioned?
that is not.
No, that finding is not there now, Mr. Sharma. Problem arises is when you are giving a direction, the finding has to be clear. Only one finding is clear, that you create a supernumerary post and give him the benefit within a period of 4 months. That is the thing which can be. So you can have at best the date on which the supernumerary post was created has to be given notionally from the date on which the 4 months has ended. That is on 15/3/2019. And from that date till the date he had expired, he'll be entitled to the arrears of the post of head assistant. And his pensionary benefits or the family pension, whatever it may be, shall be worked out in that manner. That is the only thing. Heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petitioner. And Mr. S. Doctor, who appears on behalf of the Panchayat and Rural Development Department of the Government of Assam. Mr. D. Bora, who appears on behalf of the District Administration. Accountant General, any person? Yes, Mr. B. Chakraborty appears on behalf of the respondent Accountant General, any Office of the Accountant General. The present writ petition has been filed by the wife of late Shyamol Nandi, being aggrieved by the inaction on the part of the respondent authorities to release all the pecuniary benefits of the post of head assistant from the date of merger of the DRDA to the Jila Parishad, including areas and grant all service benefits to the petitioner, and also for directing the respondents to grant compassionate family pension to the petitioner from the date of death of her husband till the date of his superannuation. Full stop. The materials on records show that the husband of the petitioner was initially appointed as an LD assistant in DRDA Hailakandi, and thereafter he was promoted to the post of UD assistant. While the petitioner's husband was serving as the UD assistant, one Santi Ranjan Paul, the then head assistant DRDA Hailakandi, resigned from his post, for which the post of head assistant in DRDA Hailakandi fell vacant. Resultantly, the project director DRDA, with the approval of the Deputy Commissioner Hailakandi by order dated 21/2/2017, promoted the petitioner's husband to the post of head assistant as per seniority of the official working there, and accordingly the petitioner on 22/2/2017, accordingly the husband of the petitioner on 22/2/2017 joined as the head assistant in DRDA Hailakandi. Full stop. It is very pertinent at this stage to take note of that prior to the promotion of the petitioner, the government of Assam PNRD department by notification dated 12/9/2016 decided to wind up the DRDA and merge the same with the Jila Parishad with effect from 1/10/2016, absorbing all DRDA born employees in the Jila Parishads, Anchalik Panchayats, etc. Full stop. The notification, however, the appropriate notification, though issued, the effect to the said merger was given on the basis of a notification dated 29/7/2017. Full stop. It was the case of the petitioner's husband. Now, full stop. The petitioner's husband, though in the meantime was promoted on 21/2/2017 as the head assistant, but at the time of absorption, he was brought within the services of the Jila Parishad as a senior assistant (UD assistant). On the ground that the petitioner was promoted to the post of head assistant while the merger procedures was already initiated, though the same was stalled for the time being. The petitioner thereupon challenged, the husband of the petitioner thereupon challenged this move, by which the petitioner was reduced in rank. The husband of the petitioner was reduced in rank from the post of head assistant to the upper division assistant by filing a writ petition which was registered and numbered as WPC number 5725/2017. The said writ petition was disposed of by an order dated 15/11/2018. At this stage, this court finds it pertinent to take note of paragraph number 40, 41, and 42 of the order dated 15/11/2018. And the same is reproduced herein below. It is seen that pursuant to the order passed by the learned coordinate bench of this court, the same was forwarded to the respective respective respondent authorities for doing the needful in compliance to the directions passed in the order dated 15/11/2018 in WPC number 5725/2017. Taking into account that there was a direction for creation of a supernumerary post, steps were also being taken from the Panchayat and Rural Development Department for creation of a supernumerary post, and proposals were therefore made. Unfortunately, while the said process was going on, the husband of the petitioner expired on 17/1/2021. Full. The record further reveals that a supernumerary post of head assistant under the Panchayat and Rural Development Department at Hailakandi Jila Parishad was created only on 24/8/2022 on the basis of the order dated 15/11/2018 passed in WPC number 5725/2017 in order to accommodate the husband of the petitioner. Full stop. In the meantime, the husband of the petitioner having already expired, nothing could be done. And resultantly, having expired, the benefits of the order dated 15/11/2018 passed in WPC number so and so was not provided to the petitioner. It is the further case of the petitioner that in view of the directions passed by the learned single judge, by the learned coordinate bench dated 15/11/2018 in WPC number so and so, the petitioner is entitled to the areas for the period from the date of merger of the respondent areas of pay, areas of the difference in the scale of pay.
Actually, since 2017, he has not been paid the salary also. Therefore, there will be a big amount.
Huh?
Since 2017, after he joined the DRD, the Jila Parishad, he was not paid the salary.
Is entitled to the areas with effect from the date of merger of the DRDA with the Hailakandi Jila Parishad, and taking into account that the husband of the petitioner had died in harness, the petitioner is also entitled to the compassionate family pension as per the scheme of the government. Are you getting to the compassionate family
Yes.
pension?
Because it was after
Compassionate
2017.
family pension at the rate of
No, I'm not getting.
as holding the husband of the petitioner as a head assistant. In
I'm
the
not-
huh?
I'm not getting the family pension also, compassionate family pension also.
You have not got?
No. Not
Okay.
paid.
And is entitled to the compassionate family pension as per the notification of the government dated
17.
it is there na kon date to bhai দিব ha ekhon ase jun konot die 2017 na
Yes, sir. 2017.
effective from 1/4 no date they give the date 24/9 if I am not have a look at it. It is under such circumstances the petitioner has approached this court. The respondent, number 3, had filed an affidavit in opposition wherein it is been stated that in view of the death of the husband of the petitioner on 17/1/2021, and the creation of the post, supernumerary post only on 24/8/2022, the petitioner is not entitled to the relief as has been sought for. It is also mentioned that it was only on account of information being not provided to the Panchayat and Rural Development Department. The supernumerary post was created on 24/8/2022, and had the death of the husband of the petitioner dated 17/1/2021 would have been brought to the notice of the PNRD department, such creation of the supernumerary post would not have been done.
I have the reply in my requisition itself. I have the reply of that. Because immediately after that, there was some condolence message to the family of the petitioner. And
Not necessary.
not
Why
necessary.
you are
That's why I'm
going into
saying-
all these
Yes,
things?
yes, Lord.
Full stop. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. Full stop. The materials on record categorically show that the husband of the petitioner was granted a promotion to the post of head assistant on 21/2/2017. However, upon the merger of the DRDA with the Hailakandi Jila Parishad, the husband of the petitioner was absorbed as a senior assistant bracket UD assistant without taking note of that the husband of the petitioner was already promoted to the post of head assistant. This led to a litigation before this court, which was registered and numbered at WPC number 5725/2017. The materials on record further show that by an order dated 15/11/2018, this court categorically held that the state government cannot deny the promotion of the petitioner as the head assistant. It was also held that the very objection raised by the petitioner, that the state government, the objections so raised by the state government, was without any merit and unreasonable, and they are to be blamed for that, for the situation. It further appears clearly that the learned court and bench have categorically held that the state government cannot deny the promotion of the petitioner to the post of head assistant. It was further directed that the state government should create a personal post of head assistant if needed to accommodate the husband of the petitioner. as head assistant in the Panchayat and Rural Development Department, Government of Assam / Hailakandi Jila Parishad. In addition to that, it was also directed that appropriate steps for accommodating the husband of the petitioner as a head assistant in the Hailakandi Jila Parishad and to release all pecuniary benefits, including areas and other service benefits attached to the post of head assistant, be undertaken within a period of 4 months from the date of receipt of the certified copy of the order. The record reveals that a certified copy of the order was duly received
On 28/12/2018.
on 28/12/2018. And the respondent authorities did not seek any extension of time from this court at any point of time. Full stop. On account of the delay in creation of the post, the present situation has arisen. Inasmuch as the creation of the post was required to be carried out within a period of 4 months from 28/12/2018. Full stop. Presently, as the facts stand, the post was created after the death of the petitioner's husband. It is further noteworthy to mention that at the time of death of the petitioner's husband, he was 56 years. And therefore, the husband of the petitioner expired while he was serving in the Hailakandi Jila Parishad. This court further takes note of the notification dated so and so.
Notification is OM number PPG bracket P 292/2017/1 dated 31/10/2017.
Dated 31/10/2017, which mandates that if an employee of the state government expires, he dies in harness, a compassionate family pension would be paid to the family members equal to that of the salary of the deceased till he attains the age of superannuation, and subsequent thereto, the regular pension, family pension. Next. This court have categorically the observations made by the learned coordinate bench of this court in the judgment and order dated 15/11/2018 in WPC number so and so is appropriate, is clear that the promotion of the petitioner to the post of head assistant, promotion of the husband of the petitioner to the post of head assistant in the DRDA under no circumstances can be denied by the state government. In that view of the matter, as on 21/12, nah? 21/12.
Yes.
When were you promoted?
Was promoted on
21/2/2017.
Yes.
The husband of the petitioner was promoted to the post of head assistant. Pusto. It is further seen that on 29/7/2017, the merger took place. And on that day, the petitioner, husband of the petitioner, was the. Huh?
Merger, my lord. It's adopted.
Huh?
Petitioner was adopted, absorbed. Because the idea was closed, my lord.
On was the department, the DRDA was absorbed into the Jila Parishad.
But the idea was, my lord, closed, my lord, and those employees were absorbed.
Were
in the-
absorbed. On 29/7/2017, the DRDA was closed, and the employees of the DRDA working in the DRDA were absorbed to the Jila Parishad. Likewise, the husband of the petitioner, who was working as the head assistant of the DRDA, was also absorbed upon the abolishment of the DRDA. But in doing so, he was absorbed as a senior assistant oblique UD assistant. This aspect was duly taken note of by the learned coordinate bench in the order dated 15/11/2018, holding inter alia that the state government cannot refute, cannot deny the promotion of the husband of the petitioner to the post of head assistant. This court further takes note of that the learned coordinate bench had directed the completion of the entire process within a period of 4 months from the date of submission of the certified copy of the order. No steps, the steps which were required to be taken by the state government for creation of the supernumerary post was not completed within the said period of 4 months. Neither there was any extension sought for. Under such circumstances, it was incumbent upon the respondent authorities to comply with the order. Inasmuch as the judgment and order dated 15/11/2018 did not create a right, but it declared the right that the husband of the petitioner was entitled to be absolved as a head assistant in the Hailakandi Jila Parishad. And the same ought to have been completed within a period of 4 months, and thereby paying the other pecuniary benefits. The inaction or the delay on the part of the respondent authorities in creation of the supernumerary post only on 28/4/2024/8.
On 28/4.
28/4/2022 cannot be a ground to deny the benefits which flows to the petitioner on the basis of the judgment dated 15/11/2018 passed in so and so. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The petitioner herein would be entitled to the arrear of pay you have not received any amount after that, na? He died also without money.
That money. Since after merger, he did not receive.
Maja, you didn't pay him a single penny.
That instruction I know. But Lordship, after his death, the CPF amount was paid to the petitioner.
Huh?
After his death, the CPF amount was paid to the petitioner.
Okay, but not the other
Not
one.
the salary and other.
Salary has not been paid. Where have you asked for the salary? Where is your statement?
Maybe pension in that my lord.
Release the pecuniary benefits to the post of head assistant for, no, you have not asked for that.
Before absorption, my lord, he was working under DRD only, it's a SNC, my lord, not under government. That is why may not be eligible for pension. But the compassionate entitled.
Why?
Because for eligible for pension, my lord, minimum 10 years for proportionate, my lord, and 20 years for full pension, my lord.
You may not be entitled for, earlier it was not there. So you may not be entitled, to- but you'll be entitled for the compassionate
Yes,
pension. Accordingly, the instant with petition stands disposal with the following year. First, the petitioner herein would be entitled to the areas of pay to which her husband would have been entitled to had he been alive. In respect to, by calculating the amount areas of that. As a head assistant, with effect from what will be the 4 months from 28 to
28/12/2018 was the date of service of the order. Then 28/4/2019 will be the date.
28/4.
Yes.
I'm sure.
Because 4 months, 1, 2, 3, 4. Yes. 4 months will be
28/3 or 28/4.
28/4. January will be 1, February, March.
Sure,
April.
na?
Yes.
28/4 with effect from 28/4/2025.
19.
2019 till the date of the expiry of the husband of the petitioner on 17/1/2021, isn't it?
Yes.
First. Number 2. It is submitted by Mr. R. Sharma during the course of the hearing that after the amalgamation, there was no payment of any amount to the husband of the petitioner or to the petitioner. Considering the above, the respondents shall make necessary verification. And if it is found that the husband of the petitioner have not received any amount from the date of abolishing of the DRDA and absorption of the petitioner's husband to the post to the Hailakandi Jila Parishad, dated 29/7/2017, the said areas be paid number 3 be paid number 3 the creation of the supernumerary post by the note communication dated 24/8 na? No, 28
24/8.
24/8/2022 shall be deemed to have been created on 28/4/2019. Next. The petitioner further be paid the compassionate family pension For the period the husband of the petitioner would have in terms with the notification dated so and so. From the period from the date the husband, for the period, the husband of the petitioner would have been in service. Next. All other benefits such as what benefits? This is DCRG
Yes.
and leave encashment.
They will calculate my, document direct, department will calculate my.
No, I'm making it very clear. Na? All other benefits such as DCRG, oblique leave encashment, etc. shall also be worked out.
Gratuity is here.
Gratuity, etc. shall be worked out, taking into account that the husband of the petitioner was promoted to the post of head assistant with effect from 28/4/2019. Next. Taking into account that the husband of the petitioner was only brought within the services of the state on 29
7/2017.
7/2017 in view of rule 138 na 38 143 which one? No, not 1/4.
Family pension 143.
Not family pension. I'm not on family pension. 108A. 108A. He would not be entitled to pension post his retirement, age of retirement. 108A. Because it is less than 10 years, no? Except you will get under 139, no? Where is that? One. Pension 138, 2. Family pension 133. The petitioner would not be entitled to family pension. In view of 108A, the petitioner herein would not be entitled to family pension. Next, the above exercise be completed within 3 months from the date a certified copy is served upon the commissioner and to the respondent number 2. Yeah? Principal Secretary?
Here in present, there is no pension.
Okay, to respond number 1.
Additional secretary.
To the additional Chief Secretary, Government of Assam, Panchayat and Rural Development Department, Government.
My lord, in this, my lord, the gratuity, my lord, for gratuity, 5 years is requirement.
That will be calculated if entitled.
5 years you will get na because of that. It is 56. 4 years here. You will get 4 years here, and here he is already there. He's there from 2017. 17 to 21, 4 years is there. And for the next another 4 years in view of the family pension, because that would not get reduced in view of the notification. So he'll get the gratuity, but he won't get that because it will be less than that years. Family pension.
Hello.
On time closed.
Lord, full time. Hello.
Yes, Mr. Bhattakur, what is
Lordship,
this?
kindly peruse the last order. Your Lordship.
Oh, yes,
Lord.
Mr. Naik. I remember. These persons have been doing all these things, huh? Hmm. The entire area, only one supervisor.
Your Lordship wanted to know who appointed this.
Now, my question is, the court inquired with Mr. P. Naik, the learned standing counsel of the JNC, as to whether there is any specific appointment letter thereby appointing supervisors, inasmuch as perusal of the supervision reports which have been enclosed to the writ petition reveals that the concerned supervisor who gave the reports carry out supervision in very vast area. In respect to one contract, it is the entire ward number 26, whereas in respect to the other, it is the entire ward number 28 and 29. Submitted that you will obtain instructions.
Paragraph 4. Paragraph 4, Lord.
Inquired with the council that is it the mandate of the tender condition that there is a requirement of supervision, and further how the supervisors are appointed as per the tender conditions. And council submit that he will obtain instructions. Para 4.
Lordship. That your Lordship, I could not find your Lordship. Because your Lordship,
Your entire basis is on the your entire basis is on the approval given by the supervisor.
Lordship, that your Lordship, so far as the appointment of supervisor is concerned, your Lordship will kindly come to page 30 for a moment, your Lordship. On the basis of letter written by the GMC, your Lordship. GMC letter,
Certificate of the third party monitoring.
Lordship. GMC letter number so and so.
The above mentioned work was monitored by us during the execution of so and so man, accompanied by the junior engineer during some scheduled works. We were accompanied by the assistant engineer and superintendent. Inspected the drain after finishing the desilting and cleaning. Haruna Nasid, lecturer. So they saw the entire ward number 26.
Lordship, that's your Lordship.
Per day.
These are people, your Lordship.
So that will be somewhere mentioned in the tender condition.
Lordship, in the tender.
That a third party certificate is required.
Lordship, in the tender condition, it is not there, I am told, your Lordship, but your Lordship has asked me as well as my learned friend, your Lordship, so far as this is concerned, your Lordship.
What is the stand taken by in the affidavit?
In the affidavit, they say, your Lordship.
Completion certificate was issued by the then executive engineer. Accordingly, the file was processed for further necessary to the higher. However, it is observed by the superior authority that no documentary evidence of supervision carried out from the third party monitoring agency were furnished. Further, no documentary photographic evidence regarding status, review, monitoring of the entire area was furnished by the then concerned demand, except the completion report. In consideration of the above, the superior authority, JMC has considered to take a decision on the matter pertaining to release of area. After verification, the committee has rejected the work carried out as claimed by the petitioner on the ground.
What has happened, your Lordship, if your Lordship allows me to submit, your Lordship, permits me to submit.
Have you put photographs here?
No, I have not, your Lordship. It is their duty to put the photographs, your Lordship. It is not my, your Lordship. That's what they have said, your Lordship. It is the executive engineer and the others. They say, your Lordship, and that will be, your Lordship, part of their record, your Lordship. And secondly, your Lordship, first year payment is made, second year payment is made, third year, your Lordship, maintenance here for that, your Lordship. Then for third year, 33% payment has already been made, your Lordship. Sudden, and so far as the other contractors are concerned, all were paid, your Lordship. Now only I was left out, your Lordship, and that too, your Lordship, after payment of 33%, your Lordship, they have taken this stand, your lordship. Then the question comes, your lordship, how can they paid me 33% for that year, your lordship? Rest they have paid first year, second year, third year, your lordship, 33% paid, and rest 66% they did not pay me, your lordship. Now they, after this, they have taken this stand, your lordship, that they, and the completion certificate is issued by their authority, your lordship. The third party monitoring at their behest, your lordship. My signature is not there, your lordship, probably in the third party.
Oh, how can I verify?
No, your lordship, if your lordship will kindly see, your lordship, they cannot create a dispute for the sake of disputing it, your lordship. That's, the point is, your lordship, on what basis you have paid me 33%? One work, your lordship. For one work, after paying 33%, how can you now come and turn around and say that no, we cannot pay since there is no evidence of work done? Then how have you paid me the 33%? That's a question, and your lordship, I have invested a huge amount of money in this, your lordship. And ultimately, your lordship, had they followed the same principle for other contractors, then matter would have been different, your lordship. So I am only left out, your lordship, of all. And after 2018 to 2020, your lordship, the work was done, your lordship. Now they did not pay me at the relevant point of time. Now, after 2 or 3 years, if they ask me to submit proof, how can I submit proof? And there is a mechanism they themselves has created, your lordship, by which this third party monitoring is done.
But one needs to look into the terms of the contract.
Lordship.
Where can we find
I,
it?
your lordship, I have asked my client to obtain one copy from the office of the GMC, your lordship, but he was told, he has submitted an application, he was told that entire copy has been submitted to their legal department. That's what they have said.
Yes.
Probably my
Mr. Naik,
friend can help
Legal
in
department.
that.
I have one copy of the contract agreement of it so far.
You do one thing, bring it by way of an additional
Lordship,
affidavit.
Lordship. No, there also, lordship, I am facing some difficulty. There is a clause as regard third party monitoring. Terms and conditions are there. Pages are 60, 61, 62, and 63. Page 60 is there, page 63 is there, page 61 and 62 is not there. So contract agreement is concerned.
How both of you want that this court should decide this factual dispute without the basis, unless the contract is given anywhere?
Clause 33 is the third party inspection.
How do you appoint him?
I'm told, lordship, this third party inspector was appointed by the authority.
No, it's okay. But how do you give him the contract?
It was through a tender.
Okay. Where is the tender? You don't have a copy?
Yes, it's the tender.
The tender will have the terms and conditions.
33, that is what I'm speaking, lordship. Clause 33 as regard third party inspection, lordship. It starts from page 60. It continues till page, lordship.
Mr. Naik,
67.
this should not be only for him. There will be many other places. This is only 2-3 words.
Lordship, today morning, this, the record has been furnished to me. In the afternoon, Mr. Lordship, I have already requested the authority to find out this case. As well
Let's have it on some other day.
Lordship.
When?
As per your lordship, continue.
12th February?
February.
12th of February? List this matter on 12/2/2026 at 2 p.m. And first of the GMC is directed to produce before this court the terms, the notice inviting tender on the basis of which the petitioners were granted the contracts in question.
Lordship, deeply obliged, lordship.
But by another ground is that for some periods, lordship, that third party inspection reports are not available.
It's okay.
And that should be verified from the petition itself, lordship.
Obliged.
I know, too. So, 245.
Deeply.
No. I don't know what you. 245. Meetings. Wait, oh, it is one. 445. That's it. What is this? 445? Yes, because of you, it is 445.
You on the basis of his own statement at paragraph 5.
Ah,
Because her name was included in the service book.
para?
Name of the second wife was included in the service. Means
Petitioner has approached the pension authority in 2020, averring that she was the legitimate first wife
the last
of
5 lines.
the petition. The
Paragraph
factum of the
five.
petitioner's first marriage was even concealed from his employer. Whilst the establishment of so-and-so as the service book and later the pension book also reflected the name of the second wife as his spouse for the purpose of nominee for family pension.
Her name was forwarded way to notice. If the paper was informed and one more statement of this paragraph.
No, it's okay, but the fact remains it was the second wife.
His own statement, paragraph 8. Have to, very low.
Factum of the petitioner's first marriage was even concealed from his employer.
Meaning me.
Lordship, paragraph 8, that the petitioner referred that she had taken the issue to the office of so-and-so, but the said respondent was also totally helpless.
That she had taken the issue to the office of the imam, but the said respondent was also hopelessly, possibly helpless, as there are nothing on record to indicate it.
His name was, no record at this, at the office of land restriction session judge, that she was married to her. No record is there. We cannot verify. And now it is difficult. Only thing is, can I suggest one thing, madam?
Please suggest.
Madam, let the sons of the.
Who is Anu Buragohai? Borgohai?
Anu Buragohai is the second wife, second wife.
Second wife.
Husband is Rupeswar Borgohai. And where is Rupeswar Borgohai's death certificate?
Rupeswar Borgohai's death certificate is at page next.
Huh?
17.
Page
7.
Rupeswar Borgohai. Wife is Anu Borgohai.
Yes.
Who are you?
I'm again, my lord, I'm the first wife. In
How
the
do
death
we know?
certificate, this was submitted on record. I have obtained it from the record.
No, how do we prove it?
Well,
That
that
you are
is-
the first one.
Well, that is what if I have to suggest that I may, since there is an order in the beginning that pendency would not be a bar for the employer, the principal employer to decide the matter. In the meantime, let the petitioner and her stepson, the stepchildren, approach with the documentary evidence. Let the district judge take a call on facts and present the report before your lordship. I will accept that. If I have to challenge it, I have to challenge that report. Till now-
Understood. The fact remains that I have to be prime facie satisfied.
Well, the
Mr.
next-
N. Borwa, this is a case of not issuing notice.
Well, this is
declaration that he is the.
The problem arises because there are nowadays whatever next of kin certificate you want, you can get it.
Hello, I have also not claimed the period for which the erroneous pension was erroneously paid. I have claimed only after the death. I'm not asking for the period.
But
which they
first
were
of
after
all, we have to
accepting.
know that you are the wife.
I know that is what the next of kin certificate shows it. Plus, there's an affidavit also with the
By?
stepchildren. The affidavit which I have notary affidavit is submitted, wherein the car belonging to my husband was allowed to be transferred to the stepchildren. They have clearly written, we are the brothers and sisters. All of them have accepted that they are in one family unit.
No, Mr. Borwa, kindly appreciate one thing.
Yes.
You had no objection when Anu Borgohai was getting the money. Then,
She died before I could raise an objection. Within 1 year, she died.
so 1 year to she got.
That is what I was.
You never raised the issue when her name was inserted in the PPO.
I never knew that, man. It was only after she was.
You don't stay there.
I never knew it was in the. I stated that. I never knew it was there in the.
But how is it possible?
Because we were living estranged, my lord. We are living estranged, separate.
Oh, estranged. Now everything has gone be good.
Kindly, paragraph 7, man.
No.
Here,
Anyways, you file one very strong affidavit. In this.
By the district executive. as an administrative authority.
Now, unless the petitioner shows something that he was married,
Exactly. We have shown that.
next of kin certificate cannot happen.
Well, the representation was.
Who is
forwarded
paying
to
for the
earlier
state
person.
government and the district? What is the basis on which you have issued the next of kin certificate? You just apply, you give it. See, date of application 12/4/2023. You thought it was necessary only for the purpose of filing the case.
No, my lord.
Anyways, list this matter again on 12th of February 2026 for further consideration. On that day, we'll think about it. Chalo.
In date with regard to item number 30. Does it feel like?
Yes. Some other day, give a date. Interim order is there, na?
Yes, my lordship.
Okay, extend kori go. At a date dili go.
Can the matter be add to any other day, my lordship?
What to? You see, I'm busy for the whole day. I'm the only judge sitting till 4:45.